right, good morning, everyone.
Morning.
Today is Wednesday, October 9th, and this is the time and place for the regularly scheduled Nevada Game Control Board meeting for the month of October 2024. Before we begin this morning, I'd like to ask everyone to please silence your cell phones so we don't have any disruptions this morning. And may I ask that you all please rise and join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Madam Secretary, has our agenda been posted in accordance with Nevada's open meeting law?
Yes, it has.
Thank you. And today we'll be covering all items on our October. Madam Secretary, let's please begin with our first public comment section.
This item is placed on the agenda to give the public to comment on gaming-related matters. Anyone wishing to address the board may do so at this time. Comments by each person are limited to 3 minutes as a reasonable time, place, and manner restriction. If board members ask questions of the speaker, the time needed to address those questions will not count against the speaker's 3-minute time period. If speakers have any handouts or written copies of verbal comments to provide for the record, please hand them to the enforcement agent in the room.
Thank you, Madam Secretary. Matters brought to the board's attention during public comment section may not be acted upon by the Game and Control Board. However, we of course want to hear comments from all the public as well as any comments from my fellow board members. Let's begin in Carson City. Is there anyone in Carson City wishing to make public comment this morning? Seeing none, let's come here to Las Vegas. Anyone in Las Vegas wishing to make public comment, please come forward, sit in the middle chair, and push the little green button that'll be to your right. Good morning.
Green when it's on. My name is Glenn Hunsucker, Hunsucker. My comments today about roulette. Every roulette table in every casino should be closed down immediately because they are fraudulent. Here is the proof. At the Orleans, one table had 27 show up 2 times in a row. The table next to it also had the number 27 show up 2 times in a row. At the Gold Coast, one table had the 12 show up 2 times in a row, and 6 spins later, the number 5 showed up 2 times in a row. At the Aria, where Aisha Molina works, the 00 showed up 2 times in a row. In the High Roller Lounge, the 5 showed up 2 times in a row. 2 employees at the Aria said they see this often, and in fact, they see a number show up 3 and 4 times in a row. I can give you 100 examples from 100 casinos where this happens every day at every roulette table. Convenient. In fact, you can go see for yourself at any casino at any time. The point is, this is proof that casinos can control the outcome of the game and allow anyone to win by allowing their number to come up. As long as this continues, there will always be a suspicion surrounding the members of this board and your motivation for not doing anything about it. Before issuing Aisha Molina a gaming license, I would want her to answer some questions under oath, such as, in the years she has walked by roulette tables, has she seen a number come up 2 or 3 times in a row? Has she had conversations with other executives or casino owners about the casino games being fraudulent? It doesn't matter exactly how casinos cause one number to come up 2, 3, or 4 times in a row. What matters is it happens, and it happens every day at every roulette table in every casino all over the world. Therefore, all roulette tables should be closed as soon as possible. Thank you.
Thank you. That statement to the enforcement agent to your left, if you'd like. Good morning.
Zachary Popple for the Culinary Union, POPL. Benjamin Navarro was going to do public comment, was delayed in traffic, so I'll turn in his comments along with mine. Thank you. My comments this morning are about owners of the largest gaming company and the second largest gaming market in the U.S. being called to the witness stand and put under oath. Counsel for the National Labor Relations Board may call to the witness stand the controlling owners of Station Casinos, Mr. Frank Fertitta III, Mr. Lorenzo Fertitta. They must appear at the ongoing NLRB trial before Administrative Law Judge Amita Tracy, since Station Casinos lost its fight to block an order that they testify. Counsel for Station Casinos challenged the subpoenas and argued that the Fertitta brothers should not be compelled to testify, arguing in October 2021 that, quote, any question designed to embarrass, badger, demean, or to sensationalize the Fertittas' personal beliefs, personal lives, wealth, outside business interests, or any such topics have no possible relevance, materiality, or other bearing on any issues before Judge Tracy. In Judge Tracy's denial of Station Casinos' motion to block or revoke the subpoenas to testify, she wrote, quote, it's reasonable to conclude that the Fertitta brothers may have relevant information that may advance the GC's case and refute any anticipated defenses. And that, quote, as with all witnesses, and the Fertitta brothers' testimony shall be no different, such testimony will not be a fishing expedition. With respect to Mr. Frank Fertitta, Judge Tracy said in August 2021 that he may have knowledge about messages in 2020 to employees that allegedly misled employees and disparaged unions. And NLRB General Counsel exhibits include a text message from then Station Casinos Chief Operating Officer to Mr. Lorenzo Fertitta about a campaign at Boulder Station that the government alleges was an unlawful management-run effort to decertify the union. In October 2021, counsel for Station Casinos sought to limit each Fertitta brother's time on the witness stand to no more than 2 hours. Judge Tracy has yet to rule on this, but we are confident that more than 4 hours of combined testimony will be required. Since the effort to block their testimony failed, we believe that each Fertitta brother should do what any of us should do if we are called to a witness stand. Give truthful testimony, answer all the questions the judge allows, and not be concerned with how long it takes. And we again urge the board and commission to assign staff persons to monitor these hearings in person, particularly when a gaming license holder is on the stand. Thank you.
Thank you. You can give the statements to the enforcement agent on your right. Anyone else wishing to make public comment? Good morning.
Good morning, Chairman Hendrick and members of the board. Albert Sino, I'm here today to unfortunately oppose the transfer of the shares in NR5 to my parents. My brother and David are here. We purchased the shares for over $20 million years ago and paid it in full. This was on the Peppermill and Wendover Casino shares. I had no notice of the meeting. The trustee, Ron Hawkins, hasn't told us anything. He hasn't given us any information. We're in protracted litigation for hundreds of millions of dollars that have went missing. I've been stolen from. It's remarkable that I've been able to survive it all, but we have, great companies and so forth. And just here to say that this is going to take not a good turn. I have new information on, it all started with a 2009 amended tax return that my parents filed. They wanted me to be part of it. I refused to be part of the scheme, and it's ended in litigation. It's been going on for years, and I don't know how to end it. Unfortunately, I have to be here, and it's very embarrassing for me to have to do this, but this is where we're at. And I hope your investigative unit will take me up on the new information that I have, and I can share it with them through the attorneys, and we can share our side of the story. And again, I apologize for doing this. This is not in my character, but I have to protect my interest, and I'm getting no participation from the trustee. There's a CFO, Kevin McCauley, my father. I don't know how much my mother knows or doesn't know, but this is where we're at. And so I have a family that was going to take all this stock, and it was going to be part of all the family estate planning. But apparently, as other monies have been taken, apparently the stock is trying to be taken as well. Thank you for your time, and we'll be here for any questions if you have anything. Thank you.
Thank you. Anyone else in Las Vegas wishing to make public comment this morning? Seeing none, that will close our first public comment section. Madam Secretary, that brings us to the next item on our agenda. Would you please read that into the record?
Pursuant to NRS 241.035, this item is the consideration of the approval of the Nevada Gaming Control Board disposition for September 2024.
Thank you. I know that myself and the other board members have had the opportunity to review the dispositions from last month. If there aren't any questions or comments from fellow board members, I would entertain a motion on last month's disposition.
I move for approval of the control board disposition for September 2024.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, that motion passes, bringing us to our non-restricted agenda this morning, Madam Secretary.
Non-restricted number 1 is the application of Gerard Crosby for licensure as an officer, director, and key employee at Konami Australia Pty Limited.
Good morning.
Morning, Chair Hendrick, members of the board, Madam Secretary. For the record, my name is Gerard Crosby. By way of a background, I was born and I reside in Sydney, Australia. I attended the University of Technology, obtained a bachelor degree in mathematics. I've been working in the gaming industry since 1994. I joined IGT as a game designer and mathematician, and then moved on to a software engineer. I moved to Konami Australia in 1999 as a senior software engineer, later taking on the role as a group manager of product development. I've been with the company ever since. Most recently, I was appointed to the role of Secretary, Director, General Manager, and Public Officer of Konami Australia. Additionally to this, I was also appointed Senior Vice President and Chief Games Product Officer for Konami Gaming International and Konami Australia. Konami Australia is a wholly owned subsidiary of Konami Gaming Inc. Konami Australia, we manufacture and distribute gaming devices in Australia, New Zealand, Asia, and South Africa. Konami Australia was licensed as a manufacturer and distributor to Nevada so that we could share resources with Konami Gaming Inc., co-develop game content, and assist Gaming Inc. with the assembly of slot machines. So both companies provide greater resource and flexibility and market advantages there. At Konami Australia, I'm responsible for the oversight of the affairs of the company. I oversee the day-to-day business activities, including overseeing the operations of IT, corporate planning, sales, financing, accounting, product development, operations, and human resources and compliance. I have 12 direct reports, approximately or currently 97 indirect reports, and I report to Steve Sutherland, who serves as Managing Director. At Konami Gaming Inc., I'm responsible for ensuring the company achieves the short-term, long-term strategies in regards to product development goals, locally and globally. This includes overseeing operation departments, including software engineering, hardware engineering, game design, and graphic design. I have 4 direct reports here and approximately 130 indirect reports. I report to Steve Sutherland, who serves as President and CEO. I visit the US around 3 or 4 times a year. Besides that, I'm in constant contact with our teams here via video conference and emails and so forth. So honoured to be here today and happy to answer any questions you might have.
Thank you, Mr. Crosby. Excellent presentation. You answered most of my questions. It seems like Council has advised you what we normally ask on these kind of applications. Mr. Light, is there anything you'd like to add?
Chair Hendrick, members of the board, Madam Secretary, for the record, Glenn Light with Sroka. I would just like to first add that In attendance, we have Tom Gingoli, who serves as the Executive Vice President, Chief Operating Officer, Secretary, and Director of Konami Gaming Inc., and Laurie Oak, who serves as the Chief Compliance Officer for Konami Gaming Inc. We'd also like to thank Agent Raquel Bridges and Supervisor David Bradford for their work during the investigation. They're a credit to the board. One item that did come up in the investigative report, which we'll just address right now, is that Mr. Crosby was appointed as a Director and Secretary of Konami Australia on July 14th of 2021, but his application was not filed until February 1st. So there was a few months delay. At the time of Mr. Crosby's appointment as a Director and Secretary, New South Wales, Australia was under very strict COVID restrictions, including lockdowns, which caused significant disruptions to the company. Also, at that time, Mr. Crosby's applications were being handled by a former employee of Australia. Since then, responsibility for licensing for both Konami Australia and Konami Gaming Inc. now reside at the Nevada office under the purview of Laurie Oak. So that's going to bring greater synergies to the company to make sure that there aren't any disconnects in the future. But ultimately, Konami takes full responsibility for the delay. They recognize that they should have been more transparent or communicated the delay to the Gaming Control Board, and we sincerely apologize for the inadvertent error.
Thank you for that, Mr. Light. I appreciate you addressing the area of concern head on. Can you tell us, was it Konami who discovered that the application was late, or was it the board had to get a hold of Konami to advise them?
I don't know, to be frank. I know that the application was filed, then there was delay as the investigation started. It then came up during the investigation. This appears to be late, and we addressed it at that point.
And Mr. Crosby, I assume you're aware of this issue, and it doesn't implicate your application or your qualifications, but it is incumbent upon you to understand Nevada's gaming regulations, and you got to be on top yourself of your own applications. If you move into a position requiring an application, you need to stay on compliance and be sure that they're filing your applications. Does that make sense?
Yeah, that certainly does, yes.
Okay. Good. All right. And I understand you've been licensed a number of times in multiple other jurisdictions. This is your first time going through the Nevada process. How would you compare the Nevada process to some of the other applications that you filed in other jurisdictions?
Certainly more extensive, but worked well with the agent Raquel on this one, and I think we got on well.
Good.
And I think she was very professional about the whole thing. So all in all, I think it was a good experience.
Great. Glad to hear it. Dr. Watkins, did you have questions for Mr. Crosby?
Yes, Chair. You were initially appointed Director and Secretary, is that correct?
Yep.
And then you moved into the General Manager position, is that?
It's at the same time. So
Okay.
appointed as a Director and Secretary and General Manager.
All occurred at the same time?
That's right.
But there was simply an amended application filed to, how did it?
Yeah, so Mr. Crosby was appointed Secretary and Director of Konami Australia in July of 2021. And then in August of 2022, he was appointed General Manager of Australia, Konami Australia. And then later that month, he was also appointed the Senior Vice President and Chief Games Product Officer of both Konami Australia and Konami Inc. We communicated those changes to the Gaming Control Board. We ultimately filed applications for every role, but then it was ultimately determined that the Senior Vice President and Chief Games Product didn't trigger mandatory licensing, so those were reversed.
Understood. And with regard to the individual at Konami who you said left the company, he or she, did they leave the company during that time, or they later left the company? At what point in time did they leave the company?
I'm going to have to defer to either Mr. Gingoli or Miss Laurie Oak for the time that that person left the company. I'm not too sure.
And when did those duties transition to the Las Vegas office?
Again, I would have to defer to Mr. Gingoli or Miss Oak.
Okay.
Ms. Oak, do you want to step up if you can answer those questions? Good morning.
Good morning. I believe that the individual who actually ended up retiring from Konami Australia left around the same time around those appointment dates. As far as I can, trying to go back a few years. But yeah, it was my understanding too that all of the information, all of the applications were in her hands to address and to handle. And unfortunately, there wasn't the communication there that should have been at the board. And I should have been probably in communication with her as well to make sure that if there needed to be an extension on any of the filings, we should have communicated that. But with respect to the appointment dates, I want to say that those were at the time that either she was on the cusp of retiring or it was right before. I can't recall specifically the dates.
Okay, yeah, and I don't expect you to recall specific dates, but I appreciate the additional information. And I'm just asking because it's a significant period of time.
I understand.
Usually if we receive late applications, they may be delayed a month or 2 months.
I understand.
And so what procedures have you all put in place now other than transitioning it to the Las Vegas office just to ensure that this doesn't happen again?
Yeah, so I am in direct communication with the Australia office. Anytime there would be any additional appointments, I'm actually going to be, since my title now is Chief Compliance Officer, I'll be handling compliance globally. So that will encompass not only Konami Gaming Inc., but also Australia. I will be working with them closely. I guarantee and promise this matter won't happen again.
Thank you so much. I appreciate your time.
Judge Assad, questions?
Thank you. Thank you, Chairman Hendricks. No questions per se. Just want to shout out to Agent Bridges and Deputy Chief Nathan Allen. They did a very comprehensive and thorough report on this application. Thank you for being here, Mr. Crosby. I know it's a long flight. You came in from Sydney?
Yeah, well, we've got the G2E on this week as well, so.
About 19 hours?
In total, yes, around about that, yeah.
Well, thanks for being here.
No, thank you.
Your resume is impressive. Bachelor of Science degree from New South Wales University, Ultimo, even as Chairman Hendrick indicated, licensed in several other jurisdictions. I'm satisfied with the explanation given by Mr. Light with regard to the delay in the filing. So I'm more than happy to support your application.
And for myself, Mr. Crosby, along with the judge's comments, based on your background and experience in many years in the gaming industry, I'm also very pleased to support your application. Appreciate you being here with us today.
Thank you.
Dr. Watkins, anything else?
I'll echo those comments.
Mr. Gingoli, anything you'd like to add since you're here and all dressed up? Perfect. Mr. Light, anything else?
Just to thank the board again for making the accommodation. To thank the board again for making the accommodation to allow Mr. Crosby to appear during the G2E. It saved him a lot of travel, so thank you.
Thank you. I would entertain a motion then on non-restricted item number 1.
I move to recommend approval of non-restricted item number 1 as read into the record by Secretary Rupert.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, the motion passes. Thank you. Good luck to you.
Thank you very much. Thanks for your time.
Thank you. Madam Secretary, please read in the next item.
Non-restricted number 2 is the application of International Game Technology PLC for a continuous or delayed public offering, as well as the application of IGT to guarantee and hypothecate assets in conjunction with public offering.
Good morning, Mr. Burnett. Good morning, Mr.
Member Watkins, Member Assad, it's nice to see you. Madam Secretary, A.G. Burnett from McDonald Toronto for the record. As Madam Secretary read into the record before you, you have a Reg 16115 request for a 3-year shelf from IGT PLC. And then its subsidiary entity IGT is requesting the ability to pledge any securities it may need to if it conducts a public offering. For the record, Mr. Chairman and members of the board, under the company's last 6K, which I believe was filed July of this year, IGT PLC shareholders' equity, I believe, is 1.5 billion. Consolidated shareholders' equity is 1.8 billion. The gentleman to my left is Mr. Claudio Demoli, who's the SVP and treasurer for the company. He can confirm that and then answer any questions that you may have.
Thank you, Mr. Burnett. Good morning, Mr. Demoli. And Mr. Burnett, I know you noticed that for Reg 16.115, clearly 1.5 billion exceeds the requirement of the Nevada Gaming Commission. I assume also all required reports under Reg 16 have also been filed by the company in timely manner with any regulatory agencies. Is that correct?
It has, Mr. Chairman.
Thank you for that. For the record, I didn't have any other questions. I did want to ask, though, if you or Mr. Demoli wanted to say anything about the potential Apollo acquisition. Is there anything you can comment publicly on that?
Yes, Mr. Demoli is prepared to make a comment on that. Please.
Thank you.
Chair Hendrick.
Push that little green button there. Thank you.
Chair Hendrick, members of the board, Madam Secretary, I can confirm that the transaction is well underway. We expect a closing of the same sometime during 2025. Separation activities put in place by IGT are progressing very well, and all filings for authorizations have been filed and are well progressing as far as we understand.
Great. Thank you for putting that on the record this morning. Mr. Burnett, have you reviewed draft number 1 dated 9/12/2024 and have any questions or comments regarding that draft?
And we have no questions or comments on that. Thank you.
Great. Thank you. Dr. Watkins, questions?
I don't have any questions or concerns. You've stated that you've met the regulatory requirements, and I'm in support.
Judge Assad.
Thank you, Chairman Hendricks. No questions per se. Thank you for being here. Did you fly in from Italy?
No, I'm actually based in the U.S.
Oh,
on the East Coast, and I was here for G2E. So thank you for making the arrangement and having us on the board the same week.
Well, it's great to have you here in person.
Thank you.
Where are you staying?
I'm actually flying out after this meeting and going back to.
Okay, because I had some recommendations for some really good Italian restaurants.
Okay.
We're going to be here a little longer. We are the world's best when it comes to fine dining, so maybe next time.
I don't know. Thank you. I appreciate that.
Nothing out of the ordinary. It's pretty straightforward, 3-year shelf order, so I'm full support of it. Thank you.
I thought you were going to say we're the best of Italian food. That would have been a stretch.
That and a lot of other dishes as well. So
okay.
It's all encompassing.
Very good. Mr. Burnett, anything else you'd like to add?
No, Mr. Chairman. Thank you for asking.
All right, then I would entertain a motion on non-restricted item number 2.
I move to recommend approval of non-restricted item number 2 as read into the record by Secretary Rupert pursuant to the order dated September 12th, 2024, draft number 1.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Thank you for being here. Thank you, Mr. Burnett.
Thank you.
Please read in the next item, Madam Secretary.
Non-restricted number 3 is the application of William Hill, Nevada 1, doing business as William Hill Race and Sportsbook, doing business as Tahoe Nugget Racebook and Sports Pool, doing business at Tahoe Nugget for a non-license racebook and sports pool only. I believe we have a disclosure on this item.
My partner is employed as an accountant at Caesars Entertainment. However, I have no pecuniary interest in this matter, and I do not believe the independence of judgment of a reasonable person would be affected by this relationship. I therefore intend to fully participate in this matter.
Thank you. Good morning again, Mr. Burnett.
Good morning again, Mr. Chairman, members of the board, Madam Secretary, A.G. Burnett with the law firm of McDonald Carano, here today representing William Hill, Nevada. To my left is the Senior Vice President of Retail Operations, Mr. Michael Grodsky. He worked on this. Mr. Chairman and members of the board, this is a fairly simple transaction. The company's requesting one kiosk for the launch of the Golden Nugget, which I believe you recently licensed under Mr. Scott Tate. Mr. Grodsky's here to answer any questions you may have, but other than that, we would kindly request approval of this application.
Thank you, Mr. Burnett. Mr. Grodsky, anything else you'd like to add?
Oh, thank you so much for your consideration. Really appreciate it.
Anything out of the ordinary, Mr. Burnett? You said it's pretty straightforward. It looks straightforward to me. Anything we're missing here?
Very straightforward. As I said, I believe it was last month or the month before you saw Mr. Tate, who's opening up this property, brand new property. Sounds like it's going to be a nice addition to the lake.
Wonderful.
I believe William Hill may have plans for another kiosk at some point in 2025, if I'm not mistaken.
Correct.
So we may come back to you for that.
Great. You, I'm sure, have reviewed the conditions. There are several of them for this potential application. Did you have any questions or comments regarding the conditions?
We did not, and the company understands those conditions.
All right. Dr. Watkins, any questions?
Out of curiosity, do you have any additional plans for the property outside of, or the sportsbook outside of kiosks in the future?
I do apologize. I missed a question. No, at this location, I'll just be a kiosk only. I apologize for that. I'm a little hard of hearing. I'm sorry about that.
That's okay. Thank you.
Judge Assad, any questions?
No questions. Very straightforward, as Mr. Burnett indicated. Shout out to Agent Lundeen for doing a great job on this, and I'm in full support of the application.
All right. Mr. Burnett, anything else?
No, we would echo that shout out and the agents before this application. I was remiss in doing that. Thanks to the agents for working on it.
Thank you. I would entertain a motion then on non-restricted item number 3.
I move to recommend approval of non-restricted item number 3 as read by Secretary Rupert pursuant to the following conditions. The licensee must comply with Nevada Gaming Commission Regulation 6.090 as it relates to the submission of an adequate internal control system in compliance with the minimum internal control standards for a computerized race and sportsbook. Any change in any agreement or the creation of any new agreement between William Hill, Nevada 1 and Tahoe Nugget must be reported to the Nevada Gaming Control Board within 30 days of such change. Prior to the commencement of operations, the surveillance system must be installed, inspected, and approved by the Nevada Gaming Control Board Enforcement Division and thereafter be maintained at or above the standard that is approved. Surveillance cameras must provide dedicated coverage of the kiosk, the casino cage, and all patrons making kiosk transactions. Once the surveillance system is completely ready for inspection, the Nevada Gaming Control Board Carson City Enforcement Office must be contacted at least 2 days prior to the opening of the kiosk to schedule a surveillance inspection. Adequate casino personnel must be available to supervise kiosk betting and to restrict all minors under the age of 21. Prior administrative approval by the Nevada Gaming Control Board Chair or the Chair's designee is required for William Hill, Nevada 1 to convert a location from a kiosk operation to a manned satellite operation or from a manned satellite operation to a kiosk operation if any licensed location utility utilizes both a manned satellite operation and a kiosk operation. Prior administrative approval or Chair's designee is required prior to closing or opening a manned satellite operation.
Very good. Thank you, Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Thank you. Bringing us to non-restricted item number 4, Madam Secretary.
Non-restricted number 4 is the application of Ike Gaming, Inc. for a disposition of securities as noted on the agenda. I believe we have a disclosure on this item.
Thank you, Madam Secretary. I'd like to make a disclosure that is not required by Nevada's open meeting law. However, it's in my belief and consistency for keeping with Nevada's full disclosure under open meeting law Mr. Ike Lawrence Epstein, who is affiliated with Ike Gaming, Inc., and I work together as executives at the Ultimate Fighting Championship, a company that I left more than 7.5 years ago. We were also minority passive investors in several other investments in the past, none of which exist today. For the record, I do not believe that this disclosure is required by law because it has nothing to do with gift, loan, pecuniary interest, or anything in an ongoing capacity, private capacity of myself in the interest of others or anyone else, nor involves any representation or counseling within the past year. Consequently, I do not believe the independence of judgment of an independent, reasonable person would be affected, nor do I believe that my own personal judgment is affected by this. Therefore, I will be fully participating on this matter as well as any future matters regarding Ike Gaming, Inc., unless, of course, other separate disclosures are required at the appropriate time. Good morning, Mr. Alonso.
Good morning, Mr. Chairman, Dr. Watkins, Judge Assad, Madam Secretary. For the record, excuse me, I'm Michael Alonso, and I'm here on behalf of Ike Gaming, which does business as the El Cortez in downtown Las Vegas. With me today, it's my pleasure to introduce Joe Woody at the table. Mr. Woody is a shareholder and the Chief Financial Officer for Ike Gaming, Inc. And also with us in the audience, it's my pleasure to introduce Kenny Epstein, who's a shareholder, Chief Executive Officer and Chairman of the Board of Ike Gaming, Inc. And with him is his son, Lawrence Epstein, who is a shareholder, president, and a member of the Board of Directors of Ike Gaming, Inc. That, Mr. Chairman, I would like to take a moment to thank your staff, recognize Agent Serenity Simpson. This agreement was signed in June. She acted very quickly and capably and got this matter completed, and we're before you today. I'd also like to take a moment to thank Sonia Vermees, who is counsel to Jeremy and Una Zarowitz, who are the co-executors of the estate of Lonnie Zarowitz. Sonia was very helpful with her part of this application, and we appreciate her time on this. As your records indicate, Lonnie Zarowitz was a very long-time shareholder of Ike Gaming, Inc. In the last few years, Mr. Zarowitz's health was failing, and there were discussions with his family about Ike Gaming purchasing his share. Unfortunately, Mr. Zarowitz passed away in March. The estate was established with a probate court, and Ike Gaming and the estate of Lonnie Zarowitz entered into a stock purchase agreement in June, and that's what we're in front of you for. That stock purchase agreement, Ike Gaming would redeem the shares essentially from the estate. It's my understanding that the matter before the probate court, all the notices have expired, notice to creditors, everything has been done. It only awaits the board and commission approval on this matter. And finally, the acquisition of the share of stock is being done through cash on hand. There's no third-party financing. And with that, Mr. Chairman, members of the board, we're happy to answer any questions that you may have.
Thank you, Mr. Alonso, and my condolences to all of you on the loss of your friend. I didn't have any questions. You answered the question I had, which was about the probate matter and where we were at on that, and you thoroughly explained that. The only other thing I want to put on the record is you said this is being purchased for cash from the company, and I understand it's being held as treasury stock if the acquisition, the transfer is approved by the commission. Is that correct?
That's correct, Mr. Chairman. It'll be redeemed and then put in treasury.
Very good. Dr. Watkins, questions?
I don't have any questions or concern. I'm satisfied by the report. Thank you.
Judge Assad.
Thank you, Chairman Hendricks. Thanks for being here. My condolences as well for the loss of Mrs. Zarowitz. It's very straightforward. Mr. Alonso did a great job of explaining everything. The report's very thorough. I have no questions or comments, so I'm full support of the application.
Thank you. Mr. Woody, anything you'd like to add?
No, just thank you. Thank you.
That little button there next to you.
Review of this very much.
Appreciate it. Mr. Epstein or Mr. Epstein, anything you'd like to say other than go Vanderbilt?
Go Vandy, for sure.
Very good. All right then, Mr. Alonso, anything else?
No, Mr. Chairman. Thank you.
All right, then I would entertain a motion on non-restricted item number 4.
I move to recommend approval of non-restricted item number 4 is read.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, the motion passes.
Thank you, Ray.
Thank you. Good luck to you. Bringing us to non-restricted item number 5.
Non-restricted number 5 are the applications of Peppermill Casinos, Inc., Wendover Casinos, Inc., for a transfer of interest as noted on the agenda. It is also the applications of Albert Sino Jr., Sandra Sino, and the Albert D. Sino Jr. 1999 Living Trust 2 for licensure as a shareholder as noted on the agenda. You also have the application of Sandra Sino for finding of suitability as a beneficiary as noted on the agenda.
Thank you, Madam Secretary. Good morning, Mr. Schreck.
Good morning, Mr. Chairman, Dr. Watkins, and Judge. I would make for the record that I'm Frank Schreck. I'm representing the applicants in this matter. With me are the two applicants that I can introduce at this point in time. One is Albert D. Sino Jr. Albert has been a licensee at the Pepper Mill since 1980. In approximately about 2000, 2001. His trust, which is the trust that's before you today, was approved by the Nevada Gaming Commission to hold shares in the Pepper Mill. Albert at that time was reapproved as the sole trustee and sole beneficiary of that trust. Also with us is Sandra Sino, who is his wife and is an applicant today to be a beneficiary of that trust and to receive approval to hold on a temporary basis the gaming stock that we're seeking to eventually be transferred. I think it's important for the board to understand, what these applications are asking, and more particularly what they're not asking. First of all, the applicants are requesting the board to determine the suitability of Albert D. Sino Jr. and Sandra L. Sino to own gaming stock that's currently held by the PCI Trust for the benefit of the applicant's sons, Albert III and David. Any transfer of the gaming stock must receive the prior approval of the Nevada Gaming Commission. The applicants are not asking the board to approve the substitution of assets or any distributions from the PCI Trust, nor are the applicants seeking the board's approval for the actual transfer of the gaming stock to the applicants. The transfer of the gaming stock is a determination that will be made by the PCI trustee in his fiduciary obligation and whose determination is subject to review in the current trust litigation. The board's approval will not involve the board or the commission in the pending litigation. It's the intervention by Albert III, who spoke today and whose remarks I won't comment or give dignity to unless you have any questions about him, and David in their proceedings that will result in the board becoming involved in the litigation. I also have with me today Proctor Hugg III, who is Albert's trust attorney, and also Pat Lundvall, who's Albert's litigation attorney, and Amelia Cargill, who is kind of a general counsel on non-gaming matters and worked very closely with me and your agents in this application. I brought them as resource people, so if you have any questions about the trusts or any of the issues involving the trust, Mr. Proctor Hugg is here to respond to those. If you have any questions relating to the trust litigation or any other litigation, Pat Lundvall is handling that on behalf of Mr. Sino. With the chairman's permission, what I'd like to do is discuss just what the applications are first, and then discuss a little bit of the background of why the applications have been filed.
Please, that'd be helpful.
So the applications seek approval to transfer gaming stock in Pepper Mill Casinos Inc. and Wendover Casinos Inc. from trusts created by the applicants for the benefit of their two sons, Albert III and David, pursuant to the terms of a declaration of trust executed by the applicants on January 4, 2000. As will be discussed, the declaration of trust gives the applicants the right to substitute property of equal value for the gaming stock in the trusts. The applicants have decided to exercise that right and, upon board and commission approval, will direct the trustee of those trusts to transfer the gaming stock to them personally, pursuant to the provisions of the Declaration of Trust. The prior approval of the Nevada Gaming Commission is required before the trustee can transfer the gaming stock to the applicants. The applicant seeking approval for the application seeking approval for the applicants to own these gaming interests are before the court of the board today. Since the applicants want to hold the gaming stock in the Albert D. Sino 1999 Living Trust, which has already been approved, to hold Albert's current interests in the Peppermill, applications to approve those transfers from applicants personally into Trust 2 are also before the board today. As previously mentioned, Albert has already been approved as a sole trustee and sole beneficiary of Trust 2. The applicants request that Sandra be approved as an additional beneficiary of that trust. If you have any questions concerning the actual applications themselves, I'd be pleased to address them at this time. Otherwise, I'll go into a little bit of the background of the applications.
Yeah, I think we'll take the applications separate from the individuals first. If you want to provide any information on them, we'll probably call them up next and have them answer questions, but you're welcome. Or wait
if I
till
can, I'll just kind of go through a little bit of the background of the applications.
Great, thank you.
For your interest, it'll be very short. On January 4th, 2000, the applicants executed a declaration of trust, which created a separate trust for each of their children, Albert III, David, and Jacqueline, which are governed by the terms of the declaration of trust and referred to as defector grantor trusts, and I'll call them the PCI trusts. A defective grantor trust reserves certain rights to the trustors, in this case, Albert and Sandra. Among those rights is the right to substitute property of equivalent value for the property held by the trust estate without the approval or consent of any person in a fiduciary capacity, which includes Ron Hawkins, the PCI trustee, who was approved by the NGC as trustee in July of 2009. As a result of these reserved rights, the trustors are responsible for paying all of the income taxes owed in connection with the earnings of the PCI trusts. Up to this point, those earnings are approximately $67 million for each child. And the trustors have then paid approximately 40 to 50% of that $67 million on behalf of each of those children during about approximately 15 years the trust has been receiving distributions based upon the stock in the gaming companies. That's the consideration for the right to do the substitution and the right to borrow from the trust. Since the PCI trusts are subject to Nevada gaming laws, the trustee cannot substitute the gaming stock in the PCI trust for Albert III and David without the transfers receiving the prior approval of Nevada Gaming Commission, which is sought here today. Pursuant to the terms of the Declaration of Trust, the trustee is not required to consent to the requested substitution or transfer. However, the trustee has an obligation to the PCI trust beneficiaries to determine in good faith the assets being substituted for are of equivalent value. To fulfill this obligation, the trustors and trustee agreed to have the PCI and WCI stock appraised by a qualified independent appraiser jointly selected by them. The value of the WCI and the PCI stock will be determined by the qualified independent appraiser selected jointly by the trustors and the trustee. The assets substituted in the PCI trusts for the PCI and WCI stock will be on more favorable terms than the other Peppermill and Wendover shareholders would receive if they sold their stock back to the gaming companies in accordance with their existing stock purchase agreements, which binds all shareholders. As previously stated, the trustee is obligated by the Declaration of Trust to proceed with the substitution once the required approvals to the Nevada Gaming Commission are received. If the trustee determines the equivalent value offered by the applicants is not sufficient, the trustee can contest this issue in the current trust litigation. If the trustee agrees that the substituted assets are of equivalent value, he will accept the substitution value given by the trustors to the PCI trusts. The beneficiaries then could challenge the trustee's good faith determination of the equivalent value, but should not be able to contest the subsequent substitution and transfer of the gaming stock to the trustees. So basically what I'm saying is that all of the trust issues are still residing with the trustee and the trust litigation in California. They're not before this board. We're just seeking the suitability finding that is a condition precedent to the trustee transferring the shares if he so determines under his fiduciary obligations as the trustee of the PCI trusts. So all of these issues that I know you've been inundated with letters and memos and information relating to the litigation there. I just want to tell you that the substitution issue that's here today that we're seeking to base the transfers on is not a matter or a subject of the trust litigation. It's never been brought up in the trust litigation. The two trustors are not parties to that litigation, so it probably couldn't be brought up in that litigation. And that I have provided a letter that hopefully you have in front of you that it's about 15 months old, which somewhat refutes Albert III's statement that they have no notice. This is a letter to the PCI trustee from his trust attorney, who acknowledges the existence of the provision for substitution in the declaration of trust. He also acknowledges that the trustors, Albert Jr. and Sandra, are considering going forward with exercising their right to make that substitution. There is no objection to that right to do the substitution. All there is a discussion and an admonition to the trustee of the PCI trust to make sure that he satisfies his fiduciary obligation in determining what the equivalent value is. So the issue of the substitution that we're going to eventually deal with the trustee on is not a subject of the litigation, the trust litigation that you've probably all heard about. So we're not asking, once again, this board to approve either a transfer or a substitution or a distribution. We're just asking for a finding of suitability of Albert and Sandra, because that's a condition precedent for the trustee to be able, if he sees fit, to make the transfer. With that.
Thank you for that, Mr. Schreck. Based on your affirmative presentation, I do have a couple of things I'd like to put on the record that perhaps you or Ms. Lundvall can address. First, I'm going to make it clear for the record that if this matter proceeds, the Nevada Gaming Control Board, and presuming the commission takes up this matter, that the commission as well would not be providing any opinion or decision regarding the valuation in any of the trusts. Is that your understanding?
Absolutely.
Would it also be your understanding for the record that the Nevada Game Control Board today and possibly the Nevada Game Commission later in the month would not making any opinion or decision regarding the substitution of assets in the trust? Is that correct?
Absolutely.
Would it also be correct that the Nevada Game Control Board today and the commission in the future would not be making any opinion or decision regarding the legality of any distributions from the trust?
Absolutely.
And finally, would it be your understanding that if the board were to make a recommendation and the commission were to make a decision regarding the applications before the board today, that such action would not run afoul of the court's order, court's injunction that is in place in California?
That's our position. This is not a distribution that has been enjoined by the court in California. This is a substitution, which is a process totally different than what is being litigated in the court. The court is litigating the issue, and Ms. Lundvall can come up and explain it even better if you'd like, but the court is litigating an issue where A3 filed a complaint with the court alleging that the trustee of the PCI Trust was breaching his fiduciary obligation by taking funds that were in the trust, in his trust, to pay down a debt that he owed his father. Okay? During that whole period of time, he agreed in court that he understood the loan existed. His president of his company sent letters to emails to banks acknowledging the loan, $100 million loan, putting amortization schedules reflecting the payments that were made out of the trust, and also taking credit for directing the trustee to make those payments. Recently, he filed a preliminary motion for summary judgment, which is 900 pages long. So as lawyers, you know, if you have a motion for summary judgment and you have to have 900 pages, it's probably there's an issue of fact somewhere lying within that. But in that, he now reasserts the fact that he doesn't know, he denies there's any loan, and he denies that that he ever authorized the payment by the trustee to pay down that loan. In that same order where the court entered the injunction about any further distribution of cash from it, not the substitution that we're talking about. The judge also found specifically that contrary to the assertions of A3, that the trustee has never breached his fiduciary obligations and that he was just acting at the direction of both A3 and Albert in the distribution of that cash to pay down the notes.
And again, just to make the record very clear, to summarize, what the applications before the board are today have to deal with a very specific gaming approval and have nothing to do with the litigation in California. Would that be your opinion?
Absolutely.
Yeah. One of our responsibilities, of course, is to protect the taxpayers of this state. That's a paramount responsibility for us. What goes along hand in hand with that is we don't want to be dragged into litigation in some family feud that has nothing to do with the state of Nevada. So you don't need to respond to that. That's a statement that I make for the record. I don't believe any action that may be taken by the board today or the commission in the future would have anything to do with that litigation. And I want to be clear for the record that we are not getting involved in that litigation. We are simply, if we move forward today, making a recommendation regarding gaming applications. State of Nevada jurisdiction, gaming commission jurisdiction regarding gaming applications and proof trusts.
I agree with you 100%, and I just would add to the fact that it's been over 50 years since I've been involved in this on the Gaming Commission and now as a gaming. And one of the fundamental tenets that I understand in gaming regulation is that the Gaming Control Board and the Gaming Commission will not get involved in civil litigation. And we're not getting you involved in civil litigation. In fact, we're keeping the board and the commission out of civil litigation by just asking for the approvals of just the suitability, and all of the other issues that we're talking about will all be decided in the courts in California and by the trustee.
And I appreciate you saying that for the record, and I completely agree. I haven't been involved in this for 50 years as you have, but that is a paramount concern is we let the parties deal with litigation, we deal with gaming matters, and I think that this applications that are before the board today are gaming matters, not in litigation matters. I would agree with your statement that we're not trying to get involved in any family feud between the parties and the family to resolve their own differences. If this were to move forward today, it has to do with trusts being approved by the Gaming Commission.
Correct, and the individual applicants being approved as owners of shares.
And we'll bring them up separately to have conversations about that, but yes, you're correct. Thank you. Dr. Watkins, did you have questions for Mr. Schreck? And we will take the individual applicants separately in a moment.
Good morning.
Good morning,
Mr. Schreck.
Dr. Watkins.
I'm satisfied by the material, the volume of material that's been presented to us, the exchange between you and the chairman and your affirmative presentation here today. I'd just like to state a couple of things for the record. One is that I don't think the issue before the board is the same issue in the litigation. Two is that I myself have no interest in getting involved in the litigation and I don't have an opinion about the litigation, and I don't want to interfere with the judge's injunction. And I'm not expressing any opinion as it relates to the substitution of assets. I think these are separate matters, but I do think that we can move forward here today.
Thank you.
Judge Saad, questions?
Yes, thank you, Mr. Schreck, for being here. That was a very thorough explanation. I just have some concerns that I haven't had an opportunity to read the trust agreement. I'd like to have that opportunity to go over the trust and see exactly what it says. I understand that the litigation in California with Judge Fenstermacher is separate to a certain extent from the matter before us today. However, there is some crossover there. Her injunction simply reads that the trustees are immediately enjoined and restrained from making and or permitting distributions from the trust related to Albert D. Sino III until further order of this court or by mutual agreement of the parties confirmed by this court. I'd just like to maybe have that judge take a look at this and see if this is indeed going to comport with her injunction. But mostly I'd like to at least read the trust, and we don't have that, or at least I haven't had a chance to read it. So I'd like to maybe continue this matter until I've had an opportunity, and the rest of the board members as well, to read the trust agreement itself.
With all due respect, there are reasons why we want to have this heard today. There's other pending motions and litigation that are based upon a misguided argument that somehow the distribution is covered by, the injunction. The distribution issue was never in front of the trust court. It was never in front in that litigation. It hasn't been. And the trust attorney, whose letter you have for Mr. Albert III, acknowledges the existence of the provision, and you can read the provision we're talking about. That's the only provision that's really important in this case, is the right to substitute, and you have a copy of the quote that's in his Albert III's attorney's letter to the trustee of the PCI Trust, acknowledging that substitution right, saying that they understand that we're going to move forward with respect to that substitution, and not objecting to the substitution at all, because he had no right to object to the substitution. It's set forth in the trust. It's not part of the litigation that's in front of the court right now, and has never been. In fact, as an attorney, it couldn't be, because the trustors are not parties to that lawsuit. They're not parties to the lawsuit. So we want to move forward today because there's hearings that are set on motions that would be obviated by our ability to go ahead and meet with the trustee and try to convince him to exercise his fiduciary obligation and fiduciary authority to go ahead and agree with the value or negotiate the value, equivalent value, and then the stock transferred.
Would you, Mr. Schreck, elaborate a little bit on that? The question the judge was asking is, if something were done this month versus giving the board more time, you mentioned that there's motions pending. Is there something that the commission needs to do this month that would affect, I believe you mentioned that the trustee obviously needs to have, I'm assuming, gaming commission approval in order to, you called it a condition precedent, I believed earlier. Is that the timing concern?
Yes, we have to have approval for the applications. We just seek the suitability finding of the two applicants to own the shares, and we're not asking, Judge Assad, we're not asking this board to approve the transfer. We're not asking this board to approve a substitution. We're not asking this board to approve a distribution, which really doesn't exist in this case, but that's what's enjoined by the court. We're not asking you to do any one of those three things. Those A3 and his brother can take up in the trust litigation where they filed all kinds of motions. There's a motion that's going to be heard before the end of this month. There's other motions that are pending, like I said, an application for a summary judgment that's 900 pages long. We want to stop that nonsense. And if we get the approval, the pre-approval from you, which does not give us approval to get the transfer, that's a condition precedent for the trustee to allow the transfer to occur. The trustee can't approve a transfer to us even if he accepts the equivalent value unless we have the prior approval. So that's the condition precedent that we have to have. This board and the commission are not involved in any of the other issues that are presently being litigated. The third has the right to go into court. He knows now we're here. There's 2 weeks before the commission meeting. He's very litigious. He can go into court and file whatever motions he wants to file in the interim period of time. But we want to move forward with this because it's very important for us to get this done. We've been waiting for a year and a half to kind of complete this process, and it's the continued litigation and filings in the trust litigation deal with something other than what we're asking board to approve. And even though we're not asking you to approve the distribution, I mean, not the distribution, but the substitution, it doesn't involve the substitution either. That's not before the trust. That's not in the trust litigation. That's not before the court in the trust litigation. What we're going to eventually do in the substitution.
Is this trust a revocable or irrevocable
trust? Irrevocable trust.
Irrevocable.
Irrevocable. And it's this defective grantor trust. Until I saw this, I didn't know existed. I thought once you made irrevocable trust, you couldn't change it. But in this, they preserve two rights. One of the right is the substitution for equivalent value of assets in the trust, and the other is to be able to borrow from the trust. And for that right, they were obligated to pay the income taxes on the distributions to the beneficiaries over that whole period of time. And I've indicated that those distributions are about $67 million each. And the taxes are that Mr. Sino and Mrs. Sino had to pay somewhere between, as trustors, somewhere between 40 and 50% of that value. So they pay tens of millions of dollars for the right to do the substitution.
Did I hear you correctly? You said for us, it's not the transfer of the interest?
It is not.
It says here, application for a transfer of interest.
Well, only because the actual transfer is not being approved by you. You're approving the ability for the trustee to transfer if he so chooses to do. But you have to have the prior approval of the Nevada Gaming Commission to transfer any shares. The actual determination as to whether or not those shares will be transferred is solely within the prerogative of the trustee of the PCI trusts. So you're not approving a transfer. You're approving their ability to have a transfer if the trustee so chooses to accept their equivalent value. So you aren't approving the transfer.
And the trustee would be acting on behalf of Mr. Sino Jr.
No, the trustee is acting on behalf of the beneficiaries, A3 and David. And so he has a fiduciary obligation to determine what the equivalent value being offered is. And is that satisfactory? Does that meet his fiduciary obligations? If it doesn't, he can negotiate a different price or different payment schedule. If they can't reach an agreement, he just refuses to transfer the shares because he hasn't gotten equivalent value. And that could be litigated in the trust estate. Or if he does agree that the equivalent value has been,
so you saying
satisfied with it, A3 and his brother can challenge that in the trust court.
Are you saying that A3 and David want this substitution to occur?
No.
They're opposed to it, right?
Yes, I never said they wanted it.
Okay.
No, they don't.
So who wants to effectuate this transfer?
The trustors that created the trust, that put the stock in
Mr. Sino III.
That reserve.
Junior, I'm sorry.
Junior, that reserve the right. That reserve the right in the trust agreement, as you'll see in that letter, it quotes the provision, the applicable provision of that trust, that gives him the right to make this substitution. And for that right, he's paid about $30 to $40 million in taxes on behalf of each one of the kids over the period of time that the trust been existing.
And why does he want to do that?
Because of personal family reasons. You've seen all the litigation. You can pretty good feeling why they don't want to continue on in a relationship.
So he doesn't want the sons to wind up owning the pepper mill?
And the pepper mill shareholders do not want sons to do that either. Bill Paganetti, who was an institution in this state for many, many years, indicated to Albert Jr. that he would sell his shares if A3 was allowed to be a shareholder. That's how bitter the relationship is with the other shareholders. And as you looked at any of the transcripts before, you'll see that the four shareholders, the two Sino brothers, who are the majority shareholders, and Mr. Paganetti and Mr. Cancero, they're like brothers. Both the other shareholders have stated in hearings that they've never had an argument since in 1980 when they got into business with a limited license pepper mill, and they built that company to what it is today. They've never had a crossword with one another. They've never had an argument.
Let me ask a question. Mr. Sino III said during public comment that he wasn't aware of this hearing today, which obviously there's open meeting law, so I'll set that aside. There's certainly notice, but this trust has been in effect for many, many years.
Since 2001, I think.
This may not be something you can answer, but why have Mr. Sino III and Mr. David Sino not come forward for licensure?
They could have at any time and had the stock distributed to them. You'll have in front of you in the next couple months Jackie Sino's application, which we filed in ordinary course, have the stock in her PCI trust, transfer her individually. We file that application and she'll be doing that.
Yeah. So the
other two,
I guess my question
my suspicion is that A3 doesn't think he'd be found suitable.
But they certainly had the right over.
Certainly.
Hey, we sit here in 2024, years ago, they could have came forward and applied to have the shares actually put into their name.
Any time since the trust was, they were approved as beneficiaries, I think in 2001 or 2002. In the last 20-something years, they could have come forward and sought to have the shares distributed to them. Nobody could have stopped them. They had the right to do that.
Good morning, Ms. Lundvall. I know you stepped forward. I didn't acknowledge you. Is there something from a litigation standpoint from our conversation that you thought you needed to address this morning?
Good morning, Chairman and Dr. Watkins and Judge Assad. My name is Pat Lundvall. I'm with the law firm of McDonald Carano, and we are counsel of record for Mr. and Mrs. Sino in the two trust litigations that have been filed. I came forward because I was beckoned forward by my co-counsel. And so if there are any questions concerning the litigation, I'm happy to answer those questions. I guess just in a very quick summary, Judge Assad, I wanted to be able to assure you that the judge's order that was entered back in 2023 that dealt with an issue on a motion for preliminary injunction, at which time was looking only at the issue of whether or not that there was any breach of fiduciary duty by the trustee. She expressly found that there had been no breaches of fiduciary duty by the trustee. It was a suggestion in an abundance of caution, since there was a dispute that had arisen, to freeze distributions into the account. But the distributions and the substitutions are two separate animals, as aptly described then by Mr. Schreck.
So it was in 2022. So why did she, sorry. Yeah, it was in 2022. So why did she issue the order?
It was a suggestion that had been made because a dispute had arisen. The evidence that was before her at the time was that there was a debt, and it was agreed by A3 across almost close to 18-year period of time that that debt should be paid with distributions coming from the PCI trust. And that evidence then was before her. There was a challenge then that was made, and in an abundance of caution, it was suggested that those distributions simply be frozen into the account on a going forward basis. But as part of that, she made express findings that the trustee had not breached his fiduciary duties then to A3, at that point in time.
Well, I mean, I haven't had a chance to read the trust itself. I would like that opportunity to read the trust.
I read through it last night, Judge. Is there anything in particular you were looking at that you wanted to ask counsel about? We're not making any opinion on the trust, too. I want to make that.
Yeah, the trust isn't really before. Trust, the only relevance of the trust is to show to the board the authority that has been given pursuant to that trust to the trustee to substitute the equivalent value for the property that's in the trust, which happens just to be the stock. That's the only relevance of even mentioning the trust in this. The trust issues are in front of the court in California, not in front of you. But I think it's important for you to understand just the basis upon which, we're arguing that the substitution is correct. And we've given you a letter from A3's trust lawyer that about 15 months ago that acknowledges the existence, that provision to allow the substitution, the fact that we are going to pursue that, and that he didn't have any objection in that letter to it. It just said that admonished the trustee to make sure that he satisfies his fiduciary obligation when he determines what the equivalent value is. But that whole issue of substitution is not in front of the trust court in the trust litigation. It can't be because the two trustors are not even parties to that litigation.
This is a privately held company, right?
Yes, it is.
So how do we know what the valuation is of the
stock? It's going to be done by, just like any other valuation is done, it's going to have to undergo court scrutiny, which this will. And we know A3 will object no matter what the value is, because that's just what he does. Mr. Proctor Hug can tell you he's been involved in hiring and retaining the third-party appraiser who has an experience in appraising these kinds of properties. And we know it's going to be judicially challenged. So we're taking great efforts to make sure that the appraisal is, going to be acceptable to a court, because we know it's going to be reviewed by a court ultimately, and that the terms of the payment we've made consistent with what a buyout would be of any other shareholder in Wendover and Peppermill casinos, except we've doubled the amount of the down payment that any other shareholder would receive if they sold back into the company, and we've reduced the years that the note would be. So we're giving A3 and David a better deal than any other shareholder that would want to sell. So we feel comfortable that that'll be acceptable by a court too. But that they can challenge, and I can guarantee.
And we've said for the record now at least 3 or 4 times.
Yeah, you're not involved in it.
We are not involved.
You have nothing
Absolutely 100% at all regarding valuation, nor would the commission be later this month. Ask any questions. Ask any questions, fine. Not involved in any valuation determinations, decisions, or opinions.
Yeah. And the good news, I'm not involved either. She is.
Go ahead, Judge.
I just, with regard to the other matters before us regarding suitability, I have some questions, I guess, from Mr. Sino.
We can bring them up.
Yeah, if we're done with, we can go back and ask further questions regarding the trust and the other applications. But yeah, if it's appropriate, Judge, we'll go ahead and bring up Mr. and Mrs. Sino.
And Judge Assad, if you have any questions about the trust at all, I have Proctor Hug here, who is the trust lawyer who drafted this and is the one most familiar with the trust.
Okay, thank you.
Thank you, Ms. Lundvall.
Albert, you want to come sit here and press the green? Sandy, you can come sit over here if you'd like.
Good morning. Push that little red button to your right. There you go. Please.
My name is Albert Dominic Sino Jr.
Pleasure. Obviously, you've been involved in the gaming industry in Nevada for many years, but go ahead and tell us a little bit about yourself. And Mr. Schreck has done a fine job of explaining what these applications are, but if you want to, for the record, tell a little bit about your history in gaming, that'd be appreciated.
Okay, well, I met Nat Caroselli and Bill Paganetti about 1977. I built a Peppermill restaurant for them in Denver, Colorado, became the landlord. In a very short period of time, we saw that we had a good working relationship. They had a piece of ground on South Virginia Street where the original Peppermill was built in Reno. And they said, we have the site. Would you like to become our partners? My brother Tom and I, that is. And I didn't know anything about gaming, but I knew about finance. My brother is a finance expert. And we're fairly young. We're in our 30s. And we said yes. And we started to I was the general contractor. I went to Nevada 1979. I got my contractor's license. And there was a builder that did not make a lot of progress. So I said, let me send my crews up and we'll build it. That we did. We worked 7 days a week. And we opened July 1st, 1980. There were 5 at one time, but the 5th was short-lived. And the 4 of us have been the board members until Bill's passing. And but his son, Billy, is the 4th board member. And we have had a great relationship. We bought Western Village in Sparks from Cy Red, the founder of IGT. We had the opportunity to purchase another operation called the Gold Dust in Wendover, West Wendover, Nevada. We in about 1974 thereabouts, we had the opportunity to buy two others. We've never built one from scratch. We've always made purchases and turned those properties around, except for the pepper mill. We've had a great relationship in our 7 years of being together. We've never had one single argument. We have had unanimity in every single decision we made. And I can't even say that with my wife. But it's hard for me to explain what a great relationship we've had and still have. Again, not one split vote. It's always been 4-0, 4-0, 4-0. At one time, we had a board meeting every week, every Thursday. Weather permitting, we would fly up. Subsequently, as the organization got larger and we started getting tiered management, now we have a quarterly board meeting, but someone can call a board meeting anytime they want. And that's what we'll do from time to time.
Thank you for that. Appreciate you being here. Obviously, as I said earlier, you've been through the licensing process and you've been involved in Nevada's gaming industry for many years. So our agents had an opportunity to update your investigative history, finances, everything else, and the board members have that all in front of us. So we're very familiar with your background, but I appreciate you putting that on your record regarding your history in Nevada's gaming industry. Dr. Watkins, did you have questions for Mr. Sino?
Good morning, Mr. Sino. Thank you for being here. Given your lengthy history in the industry and all you've done, I don't have any questions. We have a report that covers pretty much everything. So thank you for being here, though.
Judge Assad.
Thank you, Chairman Hendricks, and thank you for being here. I appreciate you being here in person. It's always easier to communicate rather than through the Zoom and the cameras and all that. So I do appreciate that you've employed a lot of people through the pepper mill and the Wendover property and other properties as well. I am very mindful of that. And I do appreciate that. You have an interesting history, to say the least. Who is Arthur Caresis?
Arthur Caresis is a deceased member of the Hells Angels, was. And I knew him through his father, who owned George's Restaurant in Pittsburgh, California, where I was born. My wife and I were both born and raised there. And but I did not associate with him, other than he was brought into my life by a third person who's no longer in my life either. He's still living, but that's who he is.
It says here you invited him to your luxury box at the Oakland Raiders football games?
The person that's called Victor Bustos invited him.
And who's Victor Bustos?
He was an ex-employee that that took care of my mother and father when they were gravely ill to their deaths. And he was employed by me. And about a dozen years ago, might have been a little bit more, we got gaming approval. He got in trouble. He was a felon. We got gaming approval to have him assist me. And but once he left my employment, I have had nothing to do with him. He's not allowed. He's a felon. I cannot be around felons, and I'm not around him.
Yeah, he pled guilty to possession of methamphetamine. Is that the felony?
Yes.
Were there any other felonies?
With him? Not that I know of. I know of that one, and that was about 20 years ago.
You associated with him for a period of time?
He was employed by me for 40 years as a laborer.
During or before the felony?
Before and during.
So why would you employ someone that had a felony conviction for methamphetamine?
Well, he took care of my father and mother, and out of respect, and they were gravely ill. And, you know, I have 2 brothers, 2 sisters, there's 5 kids in the family. And he was best suited to take care of it and to take care of them, and he did.
And this is while you had a gaming license?
Well, I've had a gaming license since 1980.
You know you're not supposed to associate with felons.
That's correct.
Let me speak to this. Victor Bustos was a very close family friend, took care of his parents for years and years. He then, when his parents died, continued to employ him. When Victor Bustos went to prison for sales of methamphetamine, when he got out, Albert continued to employ him at his ranches and other things. When we went in front of the commission to settle the red-legged frog case, literally 20 years and 1 month ago, they conditioned his license not on not having any association or relationship with Bustos, but only that he could continue the employment of Bustos. But Bustos could not go to the Pepper Mill or any of the licensed gaming casinos and couldn't get complimentary privileges or rooms or anything else. But he can continue his relationship. The board allowed that to happen. Subsequent to that, as you probably see from your report, Mr. Sino is an avid hunter all over the world, and he was head of the Safari, I think it's a Safari Association. What's the name?
Safari Club.
Safari Club. And they would have their annual meeting at the Pepper Mill. So Bustos always assisted him in doing those things. So we went to the gaming, I filed a petition with the gaming and the commission to allow Mr. Bustos to accompany Mr. Sino for that specific purpose once a year. That was approved by Chairman Nylander. I did the same thing the following year when they went up there. The third time, Chairman Nylander said, "Why do you keep doing this? Why don't you just ask to have the condition with respect to Bustos removed from Mr. Sino's license?" I did that. That condition was removed. So there is no impediment to Mr. Sino associating with Mr. Bustos. He doesn't associate with them anymore because with all the things that Mr. Sino had done for this young man, or now not a young man, for all of these years and stuck by him when he got out of prison, he just abruptly quit on him. Our information is that he's associated with or either works for A3. So he is no A3, Albert III.
Oh, Albert III.
So he is no longer a person that Albert Jr. associates with or wants to associate with. But he could associate with him if he wanted to.
And then Arthur Carassis, you said was who?
He was the son of a restaurant owner, a popular restaurant owner, a small restaurant, a coffee shop, where the small town of Pittsburgh, people would go to have breakfast, lunch, and they had the dinner, they had the mashed potatoes and string bean type. It was just a family dinner, and he was there. He worked for his parents. Then he decided to become a Hell's Angel.
And he was convicted of distributing 40 pounds of methamphetamine, is that right?
That's my understanding. I read that in the paper also.
And what was your relationship with him?
I didn't have a direct relationship. He was a friend of Victor Bustos.
You had no contact with him?
I saw him from time to time, yes.
In what capacity?
In passing. I had no relationship. I'm a lot older than he was. And
how long has he been dead?
What I read in the newspaper, I have no firsthand knowledge that he was killed in the desert in Central or Southern California.
How long ago?
I'd have to, years ago. But I have no firsthand knowledge.
After he was a member of Hell's Angels, or?
He was a member of Hell's Angels. Now, whether he was still and why he was murdered, I have no idea.
And it says here you invited him to your Christmas party a couple of times in 97, 98?
Yes.
Through
Victor Bustos.
Why would you do that? You're not supposed to associate with those kind of peoples when you hold a gaming license.
That's correct.
So why would you invite him to your Christmas party not once but twice?
I believe it was because I knew him when he was a kid, and it was probably hard for me to fathom that he was there, but it wasn't directly to him. It was through Victor Bustos. I don't associate with, I associate with business people. And
you also invited Carassis to your luxury box for the Oakland Raiders.
Victor Bustos did, and it was photographed. That's my understanding. I know it was because I saw the pictures. I was not there.
Says here you also gave him business advice?
Business advice? No, I did not. Victor Bustos?
Correct.
Or
Correct.
I don't know if he had a business.
Says here you were unable, to the agents, you were unable to provide our agents with a reason for this association with Carasis.
I think he did explain what the relation. He was a friend of Bustos, and he was the son of a person in Pittsburgh. It's a small area, very small town, and his father ran the major restaurant there, and so he got to know all of the kids and the father and everything else before the kid obviously became a bad kid. But he didn't have any association with them after that. And the association was related to Mr. Bustos bringing him to these different affairs. And from my understanding, Carasis has been dead more than 10 years.
Who is Mark Davis?
He was another local boy from Pittsburgh. And he was a Hell's Angel.
Hell's Angels?
Yes, sir. Yes.
Was he convicted
Judge.
of 40 pounds of methamphetamine in Missouri?
That was
Attempting
that was Carasis.
Says Davis too.
That I'm not sure. I don't know anything about that.
Says that you admitted to the Gaming Control Board agents that you knew Davis was a convicted felon and a member of Hell's Angels. Is that correct?
I don't know of Davis being a felon.
He was invited to your annual Christmas party as well?
Yes.
You knew he was a member of Hell's Angels?
Yes.
Why would you invite someone that's a member of Hell's Angels, another member, this is the third guy, to your Christmas party?
Well, there was two, Judge. It was Victor Bustos, to my knowledge, was not a Hell's Angel. He associated with them, but not a Hell's Angel.
So why would you invite the two?
Well, these were local kids. Davis, his father was.
You have a gaming license.
I know.
You're not supposed to do that. It shows poor judgment.
Well,
wouldn't you admit that?
In hindsight, it's poor judgment. Yes, Your Honor.
And I guess it says your wife gave him a $500 check for a wedding present?
Yes.
And then who's James Couchman?
James Couchman was a local person also.
Twice convicted felon.
Couchman was?
That's what it
If
says
he
here.
was, I don't know anything about that one either.
It says you knew he was a convicted felon and you still invited him to your annual Christmas party. And you gave him legal advice regarding another arrest.
He asked me about legal advice, and I said, if you're innocent, take a lie detector test. And I didn't give him anything more than that.
It just, it's amazing to me, someone so successful as yourself and as smart as you are would associate with Hell's Angels. I mean, that is one of the most notorious gangs in the country. They're involved in everything from production of methamphetamine to murders to trafficking in drugs to sex trafficking to human trafficking to you name it. And they're on the number one hit list for the all law enforcement authorities, federal, state, and local. Why in the world would you associate with them while you have a gaming license?
Well, in context, it's not an association like we're friends.
No, but you're inviting him to the Christmas parties, you're inviting him to the box at the Raider games, you're giving them money for their weddings, you're doing all kinds of stuff with them. I mean, it's hard to deny that you didn't have a friendly relationship with these
Judge,
guys.
if I can explain Davis, he married a girl that was the daughter of a good friend. And so we did not attend the wedding. My wife gave him a gift. If it was $500, then that's probably what it was.
If I can say something, and that is that aside from Bustos, but when you deal with Carasis and this Davis, those aren't its type of associations that are prohibited in gaming law. They're acquaintances, and that's been resolved in a bunch of different cases. You can have a passing acquaintance, but the fact that Bustos invited him to be in the box for a football game and Albert wasn't there is not an evidence of any kind of close association. The fact that he knew Carasis because of his father, he didn't associate with him, he didn't do business with him, he wasn't a friend. He was invited, as a lot of small town people would be invited to their Christmas party because they still lived in the small town and everybody knew one another. But there is no association in the terms of what the regulatory process prohibits. That's a real association as opposed to an acquaintance.
So tell me about this red leg frog situation.
I built a large subdivision, 3,000 lots. There was a detention basin detaining water flows. California, we have laws that you can't discharge waters in the waters of the U.S. So the area was bone dry. We dug a detention basin, and it was probably the size of this room from front to back, right to left. We put a standpipe in the middle of it with a rock pack around it, with a perforated pipe. It silted up, and I had an underground construction. I told them just get a chain, hook up the pipe and take it off so it drains. And there was two red-legged frogs, and the red-legged frogs died.
They were on the endangered species list?
Yes.
And that was a subject of count 3 of the complaint against you?
Count 3, Your Honor, I don't.
There was a complaint that was filed that dealt with the red-legged frog incident. That complaint was resolved over 20 years ago.
Right.
The issue of the red-legged frog was probably 26 or 7 years ago. Mr. Sino's construction company is one of the largest personally owned construction companies building homes in Northern California, and he builds them in other states too. He never had this issue before. The red-legged frog issue in the 20-something years since that time, he has not been similar regulatory problems. So this was one incident in a 40-year career. And when you look at, and you probably know the extent to which California places burdens on developers in no matter where they build, to be able to exist and have no issues basically except for this one, and that was over 20-something years ago, is actually a credit to Mr. Sino's ability to follow guidelines and regulations, both federal and state. And since this was resolved by the Gaming Commission, it's really an issue that shouldn't be in front of the board today, basically, because it was issued, he paid a fine, and was obviously under scrutiny from that point forward, not to get involved in anything similar to that, and he hasn't.
It just goes to his judgment. So the West Coast Home Builders, that was the company you were affiliated with?
West Coast Home Builders is one of we have 150 entities. That's one of them.
And they pled guilty to 2 misdemeanor counts of knowingly and willfully taking a species listed as a threatened endangered species under the Endangered Species Act in violation of federal law. And then but you knew this, they told you about this, right? That the frogs are on the endangered species list at the time?
Yes.
And that was before you drained the pond, right?
I drained it.
After you were aware?
Yes.
You were violating federal law?
Yes.
Why would you do that?
Well, there were no frogs there before. It's an area that was bone dry. And if they came from somewhere, I guess I thought they can just go back. But it was in the line of my development. Like I mentioned, I had 3,000 units and we're maybe 500 units into the project. And because there was no sumps, no lakes, no water holes, nothing. So where they came from, I have no idea. But I thought if I drained it, they'd go back to where they came from.
I mean, that's your reasoning for it, but is it fair to say you intentionally and willfully violated federal law?
Yes.
Would you say that that shows poor judgment on your part?
Yes.
But once again, that issue was resolved with the federal government. It was resolved with the state of California. It was resolved with the state of Nevada Gaming Commission.
I understand.
And it's a long time ago. I mean, even if it hadn't been involved, even if it had not been involved, the fact that it's that long ago shouldn't adversely reflect on his suitability 20-something years later. But he did resolve it with Nevada Gaming, paid a fine, paid a fine to the federal government.
I get it. It's in the record. To me, it just shows a pattern in practice, a history of exercising poor judgment while possessing a Nevada gaming license, a willful disrespect for laws, rules, regulations, because he wants to build a house or a building or a company or a factory, and he wants to associate with Hell's Angels, and he wants to do all these things because I guess he's above the law.
Judge, I think that's absolutely unfair. Yes, did he willfully violate the federal law? Yes. And did he settle that with the Justice Department? Yes. Did he settle it with the state of Nevada? Yes. These other, Bustos is a person that he could associate with today, according to Gaming. Gaming looked at Bustos and allowed him to associate with him, and actually asked me to go in, Chairman Nylander, to remove the condition on on Albert's license that prohibited Bustos from going into the pepper mill. The other two people are not associations in the way that associations reflect upon suitability. They were young people that grew up in the small town that he did, that had relationships with the parents, and he didn't have any association. He knew them and didn't involve himself with them in the fact that they went with Bustos to a ball game where Albert wasn't present and didn't invite him, or went to their Christmas party where everybody in town went to. That's not a reflection of horrible judgment or something that would find a person unsuitable.
I'm just going by what's in the report.
I understand, Judge.
Or move to Mrs. Sino. These microphones are driving me crazy.
That's fine. Go right ahead.
Good morning, Miss Sino. I believe this is your first time. Your husband said he's been involved in the gaming industry for coming up on 45, 50 years, but this is your first time being in front of Nevada's gaming regulators. Is that correct?
That's correct.
Great. Why don't you tell us a little bit about yourself?
I'm a housewife. I'm a mother. I don't have a job other than that.
That's a big job.
It is. I go out with girlfriends for lunch, go to the movies. I do see Victor for lunch every now and then if he calls. And other than that, I have regular, everyday friends. I'm not associated in work. I know people in Albert's office, but just on a friendly basis.
And you haven't been involved in the Peppermill or Wendover properties?
No.
It's not your intention to be involved in the operations?
No.
I feel sorry for you, for the family feud that your family is going through. You as the matriarch of the family, I'm sure this is not easy on you, and appreciate you being here with us today. I've gone through all the materials, and you having gone through the process over the last year or so with our gaming regulators, I'm sure you now see how involved and how serious we take being involved in the gaming industry, correct?
I do. I mean, I've always understood that it was very serious because my husband's always been part of it. But I'm glad I'm not involved.
Understood. And these applications, these have to do with your family trying to do estate planning, which I commend anyone who comes before this board and works on estate planning. I always commend them because that solves issues not only for the family, but it keeps issues from arising for the gaming regulators in this state if something were to happen to the people who are the settlers of the trust, or worse, no trust at all. We get involved in a lot of situations where we stand here and we say we're sorry for the loss of your family member, but at the same time, somebody may have violated our rules. So again, I always commend anybody who gets involved in estate planning. So I thank you for that. Again, as I said, our investigators went through your background, your finances, what you've done in Nevada, your involvement with your family, and I didn't have any other questions for you. I'm pleased to support your application, and I understand what your application's about and that you're not asking to be involved in the day-to-day operations of these licensees.
Exactly.
Right.
Thank you.
Dr. Watkins, questions for Ms. Sino?
Good morning, Ms. Sino. Thank you for being here today. When you said you have lunch with Victor often, you meant Mr. Bustos, right? Is that right? Or is there someone else you're referring to?
Usually he'll just call and say, we have a local restaurant in Pittsburgh called the Mecca. And he'll call and say, do you feel like going to the Mecca? And I say, yeah. And so we have lunch and then it's goodbye and I go my way, he goes his way.
And so you're referring to Mr. Bustos, is that right?
Exactly,
Okay.
yes.
And you said that's just an occasional lunch?
Exactly.
Okay. All right, well, I don't know how you want to proceed with regard to Mr. Sino, if you wanted me to address him or.
Yeah, if you have questions, let's do this first. Judge, did you have questions for Ms. Sino?
Thank you, Chairman Hendricks. Ms. Sino, thanks for being here. And my heart goes out to you. I can't imagine the emotional strain that you must be experiencing between trying to deal with the situation before us with respect to your children and your husband. I empathize with you. I can't imagine what that would be like. So my heart goes out to you.
Thank you.
And Member Watkins, if I skipped you for questions for Mr. Sino, please go ahead and ask those now. Thank you, Ms. Sino.
Thank you.
I just had a couple of quick follow-up questions. Actually, one is for Mr. Sino and one is for Mr. Schreck. Mr. Sino, I think you already said this, but can you repeat again how long it's been since you have been associated with Mr. Bustos?
Not quite 2 years.
Okay.
He quit and I disassociated myself with him 100%.
And can you explain the terms of him leaving employment?
He started dating my cousin and she was more important than his job.
Okay.
He abruptly quit after 40 years of zero notice. And I just didn't feel that was appropriate.
Okay.
And I haven't talked to him since. He's not allowed in my office. He's not allowed to call me, and I won't talk to him. And it's just that simple.
So when you say that he quit, where was he employed?
He was in my office. He worked for Aldecino Construction.
Okay. So in your construction business, not related to your gaming business, is that correct?
No, he's never been involved in gaming.
Okay. Mr. Schreck, how long has it been since the court lifted the condition?
On Bustos?
Yes.
Okay, but even before they lifted the condition, they allowed him to associate and be employed by Mr. Sino. The only condition was that he could not be comped or be present at any Peppermill casino owned by the Peppermill Group. So then we started getting a waiver so Bustos could accompany Mr. Sino for the Safari Club at the Big Peppermill in Reno. And after about the third time of getting an annual waiver, Chairman Nylander said, look, just quit filing these petitions and just ask for to have the condition. So at no time have the Nevada gaming regulators, in spite of the fact that he was a convicted, at no time have Nevada regulators said that he couldn't associate or employ Mr. Bustos. They just said he couldn't be on the premises, and then that condition was removed. And now he doesn't have, he could still, without any problem, employ Mr. Bustos, according to the Gaming Control Board and the Gaming Commission. But he for personal reasons, that relationship has been terminated.
No, I understand completely, but could you state again for the record, how long has it been since that condition was lifted?
I don't know how long ago was Mr. Nylander chairman of the Gaming Control Board.
Okay.
But time flies when you're having fun. So it was, it had to be 15 years ago, 10, 15 years ago.
Okay, understood. So it was a long period of time.
Long time ago.
Right, understood. My interpretation, I think, is probably similar to yours in that I don't understand our regulations to require licensees not to have a friendly relationship with people who have been convicted of a felony. That's not necessarily my understanding. So, yeah, I'll just put that on the record.
If I could elaborate, that is the case because I kind of litigated this a long time ago in front of the Gaming Commission when I was a professional gambler, and a lot of the poker players he played with, some of them were people of ill repute, but they were just people playing in the game, but they had lists of the people that he played with. So the question in front of the Gaming Commission is that the kind of association that falls within the prohibition of having those kinds of relationships, or is it merely an acquaintance? And the board and commission found that was merely an acquaintance. It was not this kind of association. The kind of association you look for that you have to preclude somebody from being involved with an ex-felon is, are you in business with them? Do you constantly meet with them? Are you really close friends? Are you areas where the person could possibly influence you in the way you deal with gaming requirements and operations? That's basically what it goes to. And obviously in this case, Bustos was okay to be associated with, and the other two, at best, it was an acquaintance and probably.
Yeah, I think the former board probably had the same position, and I don't disagree with the judge in that it was, his previous associations and some of his decisions may have reflected poor judgment, but I also think that there has been a long period of time since many of those associations and those poor decisions, and I think people's judgment can grow. I think over the years, as you engage in business and as you engage in your relationships, that you develop better judgment for those things. And so I don't see anything recently where I'd say, that he's expressed poor judgment.
Thank you.
Thank you, Dr. Watkins. I would tend to agree that the passage of time means something to me here. The decisions you made 20 years ago, Mr. Sino, would have affected me a lot more if we were sitting here 20 years ago. But I think you've separated yourself from those. You made some bad decisions regarding, issue regarding a federal matter. The Gaming Commission, as Mr. Schreck said, dealt with that 20 years ago, so I'm less concerned with that. Editorialize, I would say that, as Mr. Schreck said, the situation of associating with, catering to, being in business with felons, the Gaming Control Board, the Gaming Commission does not tolerate anybody being involved in the gaming business who may be involved with a criminal, who may be involved in criminal activity. You tend to have ongoing criminal activity around you. That concerns the board and commission greatly. If it's something, as Mr. Schreck said, an association, got to be very careful. We advise all applicants, as you know, being in this industry for decades, to be very careful who you associate with, especially in a business situation. And so I know that this industry is highly regulated and you've been involved in it for many years. So I would just tell you to continue to be very, very careful with your associations and even in your businesses outside of gaming. As you know, what you do outside of gaming can affect your gaming license. Yeah. Judge, anything else for Mr. and Mrs. Sino?
No, thank you, Chairman.
All right, then, Mr. Schreck, anything else you'd like to add?
No, just to reiterate the fact that we're just here for findings of suitability and issues that are involved in the trust litigation.
Thank you for that. And yeah, we've, I think, made that extremely clear for the record. To the extent we haven't, I'll go ahead and explain one more time. any recommendation for approval today that may happen by the board, any approval that may happen by the commission for the transfers of interest regarding this matter on today's agenda have to do with the Nevada Game Control Act. The board's authority to recommend, the commission's authority to approve have nothing to do with a determination of whether or not such transfers may be affected regarding laws outside of Nevada. That has to do with litigation, separate and apart from what we're dealing with today, including any orders the court may issue, has nothing to do with this gaming control board.
That's what I understand. This is purely a finding of suitability hearing, and it has no opinion from the board, and hopefully eventually from the commission that impacts one way or the other on the trust litigation issues.
Very good. Then if the other board members don't have questions, I would entertain a motion on non-restricted item number 5.
Chair, did you want to add any condition language, or did you just want the statement to stand on the record as it relates to the our limited position here today, that which doesn't interfere with litigation?
If you have a condition you feel comfortable making, I'd certainly be willing to hear that, but I don't believe personally that a condition would affect the trust if we were to make this recommendation to the commission today, but I certainly would be willing to entertain any condition you would like to propose.
I am not sold on the idea of a condition, but I think we've recovered it and we've covered it and we've reiterated it, put it on the record what our decision here today stands for. But I turn to the judge and ask whether you might be interested in a condition.
What did you have in mind?
Okay, I'll read a potential condition. And that would be the transfers of interest of Peppermill Casinos and Wendover Casinos recommended for approval by the Nevada Gaming Control Board on October 9, 2024, and approved by the Nevada Gaming Commission on October 24, 2024, are recommendations and approvals under the Nevada Gaming Control Act only. The parties to the transfers shall determine whether the transfers are permitted under other law, including without limitation court orders prior to effecting any transfers.
Yeah, I think that's a good condition. It alleviates my concerns with respect to the suitability. I think with the passage of time, I think you've learned your lesson, so to speak, and will not be making these kinds of decisions moving forward. With regard to the transfer of interest, I believe that condition alleviates my concerns as well.
Green button. I have a concern about the last phrase in that, because that does involve itself in the litigation. It actually, the statement that prior to effecting any transfers, if it's after court order in a period, there's no problem, but prior to effecting of any transfers, that actually tries to modify the trust agreement, where the trust agreement allows the transfers. By the transferee, you're not approving any transfers. You're not involved in the transfers. This puts you involved in the transfers, because now you're creating a condition and a restriction that doesn't exist in the trust. It doesn't exist in the trust litigation. It doesn't exist anywhere. So you're creating a restriction on the ability to transfer, which I think involves you in the litigation, and I think it's not appropriate.
If I have not made it clear, I want to make it extremely clear. This body has no interest in getting involved in this family feud. We have no interest in getting involved in the litigation in a court in California. So, Mr. Schreck, if you believe that part of that condition may cause that to happen, I'm absolutely opposed to it.
It's just the last phrase. The rest of it's fine, and we've already agreed.
Let me turn to the Attorney General's office. Senior Deputy McKella, did you understand his concern?
I did, and I think maybe we can clarify. The last line again was that the parties to the transfers shall determine, not the court. whether the transfers are permitted under other law, including without limitation court orders, prior to effecting any transfers. So the condition would go to the parties would make that determination. It doesn't require a court to weigh in. It's just stating the board is not making that determination.
I don't know though if the parties make that
Yeah, the
determination. I think
if the
that's the
parties include
trustees.
A3 and David, that they're not part of this.
Yeah, it's a trustee issue.
It's the trustee.
Yeah.
That makes the issue.
If we were to strike the part about prior to effecting any transfers, does that change it, Mr. Schreck? So
Yes,
the
that's,
parties
then it's fine.
The
Then
parties to the transfer shall determine whether the transfers are permitted under other law, including without limitation court orders. That seems to me that's a legal question. That's not a condition to a gaming license. If you took out that whole sentence, you would.
Well, you know, my suggestion is that what the board, I believe, wants to accomplish is to distance itself from any litigation. I think we made it very clear on the record that these applications are only for the suitability findings of Mr. and Mrs. Sino. Has nothing at all to do with effectuating a transfer. It has nothing to do with effectuating a substitution or effectuating a distribution. Those are all issues that'll be resolved with the trustee and with the court in California.
I get that. I'm sorry. I understand that, but the finding of suitability is a condition precedent to any transfer of interest by the trustee.
No, I understand that.
It's
That's
hard
what
to
we're
escape
asking.
that.
That's why we're asking for it. But that doesn't impact any of the issues that are involved in the trust litigation. And the substitution we're talking about isn't even in the trust litigation. But we're acknowledging the fact that none of those, either the distribution, a substitution, or a transfer are part of this proceeding. We're not asking your approval for any one of those three. We're only asking for the suitability findings so that if in fact the trustee determines that there's equivalent value and the shares are transferred, that we have the prior approval necessary to it. Otherwise, we can go to the trustee and he's going to say, well, I can't do it because you need the prior approval of the Nevada Gaming Commission. So,
I get that. My concern was that I hadn't read the trust itself, but I'll take the chairman's word and explanation, his understanding that that language is in the trust that allows you to consummate this transaction in the way you've described. And so with that, I will acquiesce, but I hope maybe the commission gets a chance to read the trust before they decide what they want to do. But I think it's important and critical that the language in the trust be read and interpreted by lawyers.
yeah, and I don't mean to drag this on, but if you, the letter that I provided you from their lawyer, you'll see the quote of the provision that we're talking about in there where he acknowledges that we have the right of substitution. That's taken right from the trust, and that's the key issue with respect to the trust. The rest are all other trust, normal boilerplate trust issues.
Great, I get that. Thank you.
So with that understanding, then, Dr. Watkins, do you believe that we need the condition, or Judge Assad, do you believe we need the condition? To me, I think it says what's on the record. I don't think that's a standard condition for a gaming license.
It's not.
I think if we just strike that last line, it would satisfy the applicant's concerns.
But the prior line just says.
Prior line too.
It's just factual. The transfers of interest of Peppermill Casinos, Inc. and Wendover Casinos, Inc. recommended for approval by the Nevada Game Control Board October 9, 2024, approved by the Nevada Game Commission on October 2024, are recommendations approval under the Nevada Game Control Act. That's just that's just a statement of fact. So it's not a condition.
And we can't do any transfer unless the trustee of the PCI trusts approve it.
I don't believe a condition is necessary, Dr. Watkins, because that is just stating the facts that the record's already said. I think everybody here, including all of their lawyers and the billable hours made this morning, for me personally, I think I've made it very clear. If anyone wants to drag in the Nevada gaming regulators into this litigation, into another state, I'm personally not going to be very happy because I don't think there's a legal basis for it whatsoever. And anybody who wants to come before this body in the future and ask for a license will have to be answering a lot of questions from me if this body or the Gaming Commission is dragged into litigation into another state. I would advise that that is not on the top of my to-do list.
That's fine. Completely understood, Chairman Hendrick. I don't necessarily think that the condition needs to be in place, but I wasn't sure whether that would help us draw consensus. I think that as read without the final sentence, it simply states the limits of our jurisdiction, basically. So again, that's not necessary. But if it helps us reach consensus, then, you know, I'm in support because, again, it's just saying what we already stated on the record. So I turn to the judge and ask whether he's in support of moving forward without the condition, and I'd be in support of that as well.
I am. That's fine.
Okay.
All right, then let's try a motion.
All right. And so there are no other proposed conditions on this one, am I correct? No,
That is correct.
I have a conditions memo that has a proposed condition on it. Oh, this is the same one we just discussed. Okay, so we'll move forward without any conditions then. I move to recommend approval of non-restricted item number 5 as read into the record by Secretary Rupert.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. I wish you all and your family good luck. Mrs. Sino, Mr. Sino, all of you in the audience today, I wish you all good luck and hope you're able to resolve these matters.
And Mr. Chairman, I mean, the length of this hearing and the discussion obviously reflects the hard work put in by Supervisor Moyle and Agent Brian Kenny. They did a wonderful job. It's a complex matter, a lot of issues involved, very detailed and long financial statement from Mr. Sino that took a lot of work to do. And so we really appreciate the professionalism that they showed throughout the investigation.
Thank you.
Good luck.
All right, Madam Secretary, how is our court reporter doing?
If we could take a 10-minute break, that would be appreciated.
All right, so we're at 11:06 right now. Our restricted agenda was planned to start at 11. We're not going to make that. So anybody here on restricted matters, I would tell you that you've got a chance to stretch your legs. I would expect that we'll start on the restricted probably closer to 11:30 and 11:40 possibly. So we're going to take a 10-minute break and come back on our last non-restricted items, and then we'll try to jump straight into the restricted agenda. So we'll be in recess for 10 minutes.
We're ready to resume.
All right, let's go back on the record, and Madam Secretary, please. Item.
Non-restricted number 6 is the application of Whitney Oliver for finding of suitability as a key employee at Golden Tavern Group, LLC.
Good morning, Ms. Okerberg. Morning.
Good morning, Chair Hendrick, Member Watkins, Member Assad, Madam Secretary. For the record, I am Erica Okerberg. I am appearing today on behalf of Golden Entertainment. Here with me is the applicant, Whitney Oliver. She is the Regional Operations Manager for Golden Tavern Group. She's a first-time applicant, so as we usually do, I'd like to have her provide a little bit of her background and tell you about her duties and responsibilities.
Good morning, please. Yeah, tell us a little bit about yourself and what your responsibilities are at Golden Tavern Group.
Thank you. Good morning, Chair. It's turned off. There we go. Okay. Sorry, Member Watkins and Member Assad. I'm Whitney Oliver, and here's a bit of background on me. I joined Golden Entertainment in 2017 as a server at our flagship store, Sierra Gold on Jones. I have since moved up to hold many different titles, including bartender, AGM, and general manager. I was promoted to the regional operations team in September of 2022. In my capacity as a regional manager, I oversee all operations for 10 locations, as well as assist with the management of our extra board employees. My role encompasses many duties, including hiring, terminations, team member development, discipline, compliance, guest relations, anything that the taverns may need. As far as reporting, I report to Vincent Russo, Director of Tavern Operations, Dan Grosbeck, VP of Nevada Distributed Gaming. I have 15 direct reports, including 10 tavern general managers and 5 culinary regional managers. Over the course of my time with Golden, I have volunteered on numerous occasions for charitable causes such as the KLUC Toy Drive and assisted in raising money for supplies for local schools in our community. In 2023, I was nominated into the Golden Women's Group, which is an affinity group for professional women in the company. The mission of GWG is to promote a support network among members and to provide mentoring and professional education for established and emerging women in the company. I am also proud to have been made a board member this year and look forward to helping others grow in their careers. With that, I would like to thank Agent Potter for her work on my application, and I would be happy to answer any questions that you may have.
Thank you, Ms. Oliver. I think you mentioned that you were over 10 locations. Is that correct?
That's correct.
Okay, I thought we had in our materials 9, so 10's quite a lot. How often do you get to each location?
So we try to be present 2 to 3 times a week in each of the taverns, spending at least 2 to 3 hours a week in each of the taverns as well.
Great. And your time-wise, how many hours a week do you spend working in this job?
That's hard to say. It is quite a bit. I would say probably 70 hours a week. We answer the phone at any given hour of the day as well. So
that's full time.
Yes.
Very good. I understand this was your first time going through the gaming licensure process, but you've been involved in gaming for quite a few years. How did you find the process, delving into your life and your finances and your history?
It definitely made me take a look in the mirror, for sure. It was a learning experience, and I'm very grateful to be in front of you today.
It's probably very clear to you now how serious the gaming regulators in the state take the opportunity to be involved in this industry, correct?
Yes, correct.
Yeah, good. Dr. Watkins, did you have questions for Ms. Oliver?
Yes, good morning, Ms. Oliver.
Good morning.
Thank you for being here with us today. Congratulations on working your way up.
Thank you.
What motivated you to pursue a degree in healthcare?
A degree in healthcare. My associates from University of Phoenix. So my niece was born. I kind of saw the romantic side of it, babies being born, and was like, I want to be a nurse. And then I realized that you have to go through the nitty gritty of that before getting to the babies. So then I switched over to the healthcare administration side, which deals with HIPAA laws and insurance and things like that. But after completing that degree, it was kind of reinforced that food and beverage and hospitality was where I was meant to be.
Okay, yeah, because my next question was, did you plan on using it? So you don't plan on using your degree?
No, it's good to have though.
Yeah, absolutely. I agree completely.
Thank you.
Judge Assad, questions?
Thank you, Chairman Hendricks. No questions. I'm happy to support your application. You definitely have a lot of experience from the ground all the way up, so I commend you for doing that and being successful in that endeavor. And I want to wish you all the luck in the world.
Thank you so much.
And I as well. I'm happy to support your application. You've been involved with Golden now, I think, for over 7 years, correct?
Yes.
Good. Yeah. Well, pleased to have you here in front of us and get an opportunity to learn a little bit about you, and always interested to hear more about Golden's operations. And Ms. Okerberg keeps us apprised all the time in terms of regional managers and how that's being worked out with our investigations division and everyone else. So I know you work closely with them. And if you have any questions or you have any issues that come up, that's we're here to help.
Thank you.
Great. Thank you. I would entertain a motion then on non-restricted item number 6.
I move to recommend approval of non-restricted item number 6 is read into the record. Secretary Rupert.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Good luck to you.
Thank you so much.
Thank you. Please read in the next item, Madam Secretary.
Non-restricted number 7 is the application of Aisha Molino for licensure as a key executive at Aria Resort and Casino, LLC.
Good morning, everyone.
Good morning, Mr. Chairman, Dr. Watkins, Judge Assad, Madam Secretary. For the record, Scott Shearer of Brownstein Hyde Farber Schreck, appearing on behalf of the applicant, Ms. Molino. Ms. Molino is to my right, and to her right is Mr. Patrick Madamba. Would like, with your permission, Mr. Chairman, to have Ms. Molino give just a brief overview of her background.
Please. Good morning, Ms. Molino.
Thank you very much, Chair Hendrick, members of the board. Thank you for taking the time to review my license application today. My name is Aisha Molino. I currently serve as President and COO of Aria Resort and Vidara Hotel, as well as the Chief Public Affairs Officer for MGM Resorts. I've been with MGM Resorts for nearly 8 years now. I started with the company in January of 2017, primarily doing government affairs. And over the course of my nearly 8 years with the company, my portfolio has grown. On the public affairs side, in addition to government affairs, I also oversee corporate communications as well as public affairs. In my capacity as President and COO of Aria and Vidara, I oversee all of the operations of those 2 properties as well as the personnel that serve there. Before joining MGM Resorts, I spent my career primarily in government service. I started as a young lawyer in a small international trade firm, did that for a few months before moving over to the U.S. Department of Commerce, where I served in the Office of General Counsel. From there, I moved over to the United States Senate, where I spent the vast majority of my public sector career. I worked for the U.S. Senate Finance Committee as International Trade Counsel there before moving over to the office of Senator Harry Reid in the Majority Leader's office. I ultimately served as his chief counsel as well as handled gaming policy for him, which is how I became involved in the gaming world writ large, and then moved over to MGM Resorts when Senator Reid retired. I would be happy to answer any questions that the board has. And thank you again for your time. And I'd also like to thank Agent Burke. She was very thorough, but very professional throughout this process. And I'm grateful for her support throughout it.
Thank you. Pleasure having you here before us this morning. Your 2 roles now, it's a couple of different hats. How do you juggle your time between running a gaming operation and being public affairs director?
It is 2 different hats. I'm very fortunate to have very strong teams that I work with, and that is a big chunk of what allows me to do this work successfully. On the public affairs side, we're structured so that I have a Senior Vice President of Government Affairs who's based in Washington, D.C., a Senior Vice President of Corporate Communications who actually is based in the Aria, as well as a Vice President for Public Affairs. And all 3 of those are extraordinary experts in their field. So they're very good at managing the day-to-day. I meet with them weekly to support, to answer questions, to make sure that we're prioritizing appropriately and directionally staying on course. At the Aria and Vidara, I have 10 direct reports. And again, these folks are people who have spent years, if not decades, really honing their crafts. So we're organized so we have functional vice presidents covering every aspect of the operations: food and beverage, hospitality, gaming operations, casino marketing, security, marketing, et cetera, et cetera. So again, a team of extraordinary professionals who provide great support. And it's my job to really set the direction, to prioritize appropriately, and to just be very hands-on in driving culture and priorities, as well as strategy for the campus.
And am I correct that you actually took this role, was that November of last year?
That's correct, sir. November 30th was my first day.
Were you commuting back and forth between Nevada and Washington, D.C. for several months?
I was for several months. I have two young children, a 6-year-old and a 3-year-old. My daughter was finishing kindergarten, and so the company was very gracious in allowing her to see through the school year before my family and I moved over. So we moved over permanently in June.
Gotcha. And for full disclosure, I looked through your background. I think we live a couple of houses apart, but we've never met, so there's nothing ethical involved here. But put that out on the record. Pleasure to have you here. Obviously, your background, your education, your knowledge of not only gaming from a regulatory standpoint, but gaming from a federal standpoint is something that's always welcome here in Nevada. So I'm very happy to support your application.
Thank you. Thank you very much, Mr. Chair.
Dr. Watkins, questions?
Good morning, Ms. Molino. Thank you for being here today. You certainly have an impressive background. You're very well qualified, and I'm happy to support your application. I don't have any questions for you, but just like to say welcome to Nevada.
Thank you very much, Dr. Watkins.
Judge Assad.
Thank you, Chairman Hendricks. Welcome and nice to have you here. You didn't really need the A team with you, but it's good to have you guys here as well. Mr. Madamba, all the way from New Jersey.
As I said before, Member Assad, just to see you.
Wasn't necessary, but I'm glad to see you here nonetheless. So your application is really impressive. Your resume is exemplary. Your whole background is stellar. I love the fact that you went to GW Law School. I have a kid there. She's graduating this year. Very good law school. Very proud of that.
Thank you, sir.
And GW trained you very well, I'm sure. And I could see why Senator Reed chose you to basically run his office as general counsel. And you probably would not have gotten elected had you not been there. So good luck to you and going forward. I noticed the 8135 is it zip code as well? I thought maybe you were a neighbor of mine as well. I'm 89134, but I think we're a couple of miles apart. So, you know, it's funny because when I first got here in 1976, basically started out in the casino business as a dealer, but before that, even a busboy, waiter, and then got into the dealing, blackjack and craps and so forth. The industry was completely controlled by white men. And I think we've come a long way. And that's a tribute to the state of Nevada. And we're moving in the right direction. And I could see from your resume, you have a tremendous amount of experience. You're eminently qualified. And it's really just a tribute to you. And it's, you know, people might say, oh, well, she's here because of DEI. You know, she's a minority, she's of color. Not true. You're here because you are qualified for this position. And congratulations.
Thank you. Thank you very much for that, Judge Assad. That means a lot.
Mr. Bonamba, I know that you and your staff spend a lot of time on putting these applications together for executives at MGM. Is there anything you'd like to add?
Nothing, Chair, other than thank you, and thank you to Agent Burke. She was absolutely terrific.
Great. Pleasure to have you here. Mr. Scheer, anything else you'd like to add?
No, Mr. Chairman, thank you very much.
All right, then I would entertain a motion on non-restricted item number 7.
I move to recommend approval of non-restricted item number 7 as read into the record by Secretary Ruber.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Good luck to you.
Thank you all very much.
Thank you. Please read in the next item, Madam Secretary.
Non-restricted number 8 is the application of Nugget Sparks LLC doing business as Bourbon Square for a non-restricted gaming license, slot machines only.
Mr. Alonso, still good morning to you.
Good morning, Mr. Chairman, Dr. Watkins, Judge Assad, Madam Secretary. Again, for the record, I'm Michael Alonso, and I'm here on behalf of Nugget Sparks LLC, which is seeking a 1-day gaming license to preserve the grandfathered gaming rights at the former location of the Bourbon Square Casino in Sparks, Nevada. It's my pleasure to introduce Christina Kim, who is in-house counsel for Nugget Casino Resort in Sparks. I'd also like to take a moment to recognize your staff, including Coordinator Barry Chilton, Senior Agent Brad Barnard, Supervisor Matt Doyle. As you know, this application was submitted very late in the process, and your staff did a great job of processing it and getting us here in time to be able to get in front of you and the commission, hopefully in 2 weeks, to be able to operate for the period of time that we need to before the expiration of the 2-year period. And with that, I'll just get into the application. It is for a 1-day license. This would be the 3rd time that Nugget Sparks has operated, as this property is across the street from the Nugget in Sparks, Nevada. The 2 previous locations, or previous times that this application was submitted and approved, and Nugget Sparks operated the games at the trailer across the street, the 2nd time would expire now on November 9th, I believe, based on your records. Management at Century Casinos, as you know, Century bought the entity in 2023, and they didn't understand the process. And the general manager, who had been through this process 2 times before and had been the licensee from the city of Sparks for the 1-day license as well, he left this summer. And so when this came to their attention on the late filing, I think they did as good a job as they could do under the short time frame. They just didn't understand the process. But since then, the new general manager, Ms. Kim, management at Century Casinos, and the compliance officer are all now up to speed on what needs to happen. It's on their calendars, and we promise you that this won't happen again. With that, if the matter does get approved by the commission, the plans to operate gaming and trailer at the Bourbon Square location from 8 p.m. to midnight on November 7th, and from 12:01 a.m. to approximately 4 a.m. on November 8th. The slot machines and security will be provided by the Nugget Casino Resort, which is right across the street, as it was on the 2 previous occasions. I understand there's a condition that this is limited to 24 hours. We're satisfied with that condition. And with that, we'd be happy to answer any questions that you or the board members may have.
Thank you, Mr. Alonso, and I appreciate you addressing the speed that this application was put in place. I would say faster than a speeding bullet. This one was rapid. And Ms. Kim, I understand it wasn't under your responsibility at the time, but pleasure having you here. And as Mr. Alonso said, I would put a red letter circle around these dates. It's a very important date. Had this been missed a couple of weeks later, be a much different conversation we'd be having. So appreciate you acknowledging our staff. Is there anything, Ms. Kim, that you'd like to add?
Good morning, Dr. Watkins, Chairman Hendrick, and Judge Assad, and Madam Secretary. Thank you for your time. I think Michael stated all the pertinent facts regarding this 1-day license. And we'd like to, on behalf of the Nugget, I'd like to extend our sincere appreciation for the staff and their hard work in getting this on the agenda in time. And we've placed this on our internal calendar. So come 2026, this late filing will not happen again. I can assure you of that.
I'm sure you won't. It is the applicant and the licensee's burden to bring these to our attention. It's not the Game Control Board's responsibility. And so the sooner you can get them to us, the easier it is on us. And because this had happened a couple times before, it was easy to move the application through. But of course, that means other people who were in our inbox now get pushed out. And as we hear from applicants all the time, the first question is how fast can you move my application? And sometimes it's just that our inbox is very full, and these type of situations that come up as being fires, we put them out. We're happy to put them out, happy to deal with the licensee, but that means that somebody else's application now gets put aside for a certain amount of time. So appreciate you putting it on your calendar and circling it.
Absolutely. Thank you.
Dr. Watkins, questions?
I don't have any questions. I just wanted to say thank you for being here, and I appreciate you acknowledging that, this application will be brought more timely in the future. Thank you.
Judge Assad.
Thank you, Chairman Hendricks. No questions. It's pretty straightforward. Just a shout out to Agent Barnard and Deputy Chief Luke Rippey for expediting this, and happy to move forward and support your application.
Are there any plans for this location now that there's been a couple of extensions and keeping this license active? Is there anything publicly you can talk about?
No, Mr. Chairman, there's no plans. The company recognizes the value in the grandfathered rights and is still trying to evaluate what they're going to do with it. But there's no plans at this point.
All right. Thank you. I would entertain a motion then on non-restricted item number 8.
I move to recommend approval of non-restricted item number 8 as read to the record by Secretary pursuant to the following conditions. The location is limited to the operation of slot machines for 24 hours.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes.
Thank you very much.
Thank you.
Thank you.
Thank you. Good luck to you. Madam Secretary, do you need a minute to switch over to restricted, or can we jump right into restricted item number 1? Or actually, we'll be going into our consent agenda. Board members, do you need a minute to shift documents?
I'm
You're
fine,
okay?
Chair. I'm ready to proceed.
You're ready? Yep. All right then, Madam Secretary, let's move into our restricted agenda. We'll be starting with our consent agenda, correct?
Correct.
All right, go ahead and read those into the record.
Restricted number 2 is the application of FT Pub 12 LLC doing as Flowing Tide Pub and Grill for a restricted gaming license, and the applications of FTP Holding Company LLC and Jason Talati for licensure as a member or manager as noted on the agenda. Restricted number 6 is the application of United Coin Machine Company doing business as Century Gaming Technologies doing business at Circle K store number 2709559 for a restricted gaming license. Restricted number 7 is the application of United Coin Machine Company doing business as Century Gaming Technologies doing business at Circle K store number 2709553 for a restricted gaming license. Restricted number 8 is the application of Eclipse Route Operations LLC doing business as ECL Gaming doing business at Jackpot Jonies for a restricted gaming license. Restricted number 9 is the application of Eclipse Route Operations LLC doing business as ECL Gaming doing business at Jackpot Jonies for a restricted gaming license. Restricted number 10 is the application of Dynasty Games doing business at Pele Utu for a restricted gaming license. Restricted number 11 is the application of Shortline Gaming LLC doing business as Shortline Gaming doing business at Fuel Bros for a restricted gaming license. Restricted number 12 is the application of Shortline Gaming LLC doing business as Shortline Gaming doing business at Fuel Bros for a restricted gaming license. Restricted number 13 is the application of Shortline Gaming LLC doing business as Shortline Gaming doing business at Fuel Bros for a restricted gaming license.
Thank you, Madam Secretary, for reading those into the record. Our board's investigation agents have worked up detailed files on each of these agenda items on our consent agenda item this morning, and reports were submitted to the board members for review. No areas of interest or concern were uncovered during the investigations, and because I'm not aware of any questions or issues with any of these items, appearances of the respective applicants were waived for this meeting. If there are any questions or comments from board members, now would be the appropriate time. Otherwise, if there are none, I would take a motion.
I will make a motion on our consent agenda items.
All right.
I move to recommend approval of restricted item number 2, 6, 7, 8, 9, 10, 11, 12, and 13 pursuant to the following conditions. As to item number 6, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved. As to item number 7, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved. As to item number 10, a sign of appropriate size which has been administratively approved by the Nevada Gaming Control Board chair or the chair's designee must be at the entrance to the location, indicating that the slot machines are available to the public to play and that patrons are not required to pay a cover charge to engage in gaming. As to item number 11, the surveillance system and/or mirrors must be inspected and/or approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, thereafter be maintained at or above the standard that is approved. As to item number 12, the surveillance system and/or mirror must be inspected and/or approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved. And as to item number 13, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved.
Thank you, Member Watkins. If there are no questions from board members, Madam Secretary, go ahead and call the vote.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. That motion passes. Bringing us to our first agenda item on the restricted agenda is number 1, correct, Madam Secretary?
Correct.
All right, please read that in.
Restricted number 1 is the application of AMEL LLC doing business as the Hush Puppy for a restricted gaming license and the application of Magdi Almer for licensure as a member and manager as noted on the agenda.
Morning, Mr. Brown.
Good morning, David Brown on behalf of the applicant. With me to my right is Magni Amir, who is the proud owner of the Hush Puppy. I don't know if you've been there before. I believe in 2025, it'll celebrate its 50th anniversary of being open. We'd like to start by thanking Agent Martirosian, who we see today. She was wonderful to work with, and we really appreciate all the help she gave us along the way. And with that, I'll let Mr. Martirosian tell you a little bit about himself.
Good morning. Push that little button to you. There's a red button to your right. There you go.
My name is Magdi Amr. I was born in Cairo, Egypt. I came to the United States in 1963, and I fell in love with America, and I became a citizen in 1970, and I went to have a graduation from Ohio State University as an architecture engineer, and then some archaeology studies in the University of Chicago. And when the Hush Puppy came on sale in this last March 2022, and I decided to buy it. I guess I like all the stuff being an archaeologist. And so I obtained it because I found out that's one of the oldest restaurant in Las Vegas, open for 50 years. So I decided instead of having it sold somebody to destroy it, so I decided to buy it and keep it and kept it running, and I'm hand-on operations.
Well, it's a pleasure to have you here, and you're correct. The Hush Puppy is quite a historical building and business here in Nevada, so glad to see that it's in new hands and that you're refurbishing a little bit. My understanding that you opened how long ago? Earlier this year, is that correct?
No, we opened, actually, it never been closed when we done the conveyance of title in March 2022. The original owner asked if we close a little bit. I tell him, no, continue open. We just took it right on. And of course, I obtained from the old people 50 years old recipes. Which we're still doing it now. And I think it's really a pleasure to see people coming and say, I used to come here as a kid, and I used to come here with my children and so on. So it definitely is a part of Las Vegas history. So we continued on. I improved a lot. I done lots of restoration work of the older stuff, you know. We removed the wall and we really rehabbed it to really look nice, put new furniture, new lighting. And we continued on, but it never closed for 50 years.
That's great. And how's business doing?
Business doing good, doing good. Lots of people coming in. We still have the best catfish in town. So, and of course we have the jambalayas, which everybody come to, and Cajun shrimp and the salad, and everything is made fresh. As I don't know if you know that, even the salad dressing, we make it fresh every day. And our coastline is to die for. We make it every day. And of course, I brought back stuff like the green fried tomatoes, which disappeared for a while, and fried okra. So everything intact.
Nice. And how many hours a week do you spend at the location?
I'm a workaholic. I there hands-on 50, 60 hours a week. I'm always in there. I'm always managing and seeing what's going on. It is a part of my hobby. I love to work, and I love restaurant business. So I've been there. I'm there all the time.
Great. Pleasure to have you here. Dr. Watkins, questions for Mr. Amir?
Good morning, Mr. Amir. Thank you for being here.
Thank you.
How many other businesses do you own?
Right now, it just mainly is a hush puppy, okay? And we have another corporation which do marketing for a timeshare company, but that's about it. But right now, it's mainly is a hush puppy.
Okay. There aren't any other businesses that you have ownership or?
I have an ownership of Amber Real Estate. It is an investment company I own, yes.
Okay. And this is the only business that you are working at full-time or involved in the day-to-day operation?
Yes, definitely.
Okay, so that's why you're able to spend all your time
Yes.
here. Okay, thank you. And I think I heard you say earlier that you were an archaeologist. Is that what you said?
Yes. Archaeologists specialize in Egyptology. That's been a love of mine for years since I was a child. So I went to get a degree in the architecture and engineering. I always want to combine architecture and engineering with archaeology because they're really very related. And then I went to graduate work in University of Chicago. And lots of people do not know that University of Chicago is the biggest school of Egyptology in the world, with a research center in Egypt and lots of work over there. So that's my love,
Very interesting. I don't know if we've ever had an archaeologist before us, but very, very good to meet you. And good to see you again, Mr. Brown. That's all I have, and I'm happy to support your application.
Judge Assad?
Yes, thank you, Chairman Hendricks. Ahla sahla? My Arabic's not too good. I know a couple of words.
No, it said it okay. Ahlan wa sahlan. Yeah, you're welcome.
I was on my bucket list was to go to the pyramids in Giza, and I finally did that. And I went to the museum that I'm sure you've been to, the famous Cairo, Egypt Museum. All the artifacts and everything was quite fascinating. I could see why you'd want to study and be an expert in that area. It's just absolutely fascinating when you think about how advanced that culture was. Was it 4,000 or 5,000 years ago, I guess?
A little bit more than that, but
I mean, it's
4,000 or
just
5,000 years, yes.
Modern and technological advances that basically form the basis for where we are today. So you have an interesting heritage and great history to fall back on.
Thank you.
Yeah, I appreciate you being here in person. I love the Hush Puppy. I was there in 1977, maybe the first time. And I hope you don't change the menu. Don't get rid of those little Hush Puppies.
No.
Go in there.
Our signature
Yeah.
sale, and I added another item, more. And the Hush Puppy, now we have the regular Hush Puppy, which everybody loved.
Yeah.
And we came out with the jalapeno Hush Puppy.
Oh, wow.
Which everybody loved that too.
Oh, yeah.
So
the problem is, though, you get filled up on the Hush Puppies before the entree gets there.
Well, you can have it to go, I guess. But
then, any chance you could add like Gibby Nai on the menu, maybe?
Excuse me?
Gibby Nai?
Kibanaya.
Kibanaya, yeah.
No, Kibanaya is the
menu?
Middle East. That's a different.
You could just call it steak tartare.
Yes, tartare. Well, that's a different. I like Kibanaya personally, and of course that's mainly a big Lebanese dish.
Yeah.
Okay, and Syrian.
Oh yeah.
So, but It doesn't go with our menu.
Well, surf and turf, you can put an item on there, you know.
A surf and turf, yeah.
So you're eminently qualified for this, along with a very impressive resume. I'm very happy to support this application, and I look forward to coming into the new Hush Puppies.
You're very welcome anytime.
All right, we'll
Anytime.
see you there. Thank you.
And it's my understanding, Mr. Amer, that you attended our restricted licensee gaming compliance seminar last month. Is that correct?
Yes, yes.
Did you find it to be informative? Did you learn about how serious we take regulation in this state?
Definitely, I was surprised the details. It's very informative, you know, and I was surprised the point about, you know, be very careful about minors, don't come around the gaming. So it was very, very important, very informative.
Good.
Very detailed, yeah.
Good. Well, I'm glad you took care of that last month, and you've got wonderful counsel here with you to answer any questions, and we're also here to help support any of our licensees. So if you have questions, let us know.
Thank you very much. Thank you.
I would entertain a motion then on restricted item number 1, if a member would like to make that motion now.
I move to recommend approval of restricted item number 1 as read into the record by Secretary.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Good luck to you.
Thank you.
Thank you.
Thank you.
Please read in our next item, Madam Secretary.
Restricted number 3 is the application of Kismet Sharda LLC doing business as Arco AMPM 42713 for a restricted gaming license, and the applications of Satish Sharda and Bhuvnesh Sharda for licensure as a member and manager as noted on the agenda.
Good morning, gentlemen.
Good morning. Thank you for having us.
Have a seat and introduce yourselves for the record.
Yes, first I would like to thank Agent Marsal for all her help and the support. And my name is Bhuvnesh Sharda. This is my father, Satish Sharda. We moved here last year from California to Nevada, and we purchased. And my father's been in business for about over 30 years in California, and I've been helping him for about 17 years. We had a liquor store in California, so along with the liquor store, we also had we also work with California Lottery Department, so we're pretty familiar with the rules and regulations of lotto and lottery. It's not the same as gaming, because gaming goes way in depth and it's more, you know, more rules and regulations than just a scratch-off ticket. But other than that, we're happy to be here. We've never been in Nevada. This is first time here, so just coming here and just finding out all the different rules that are different from California, and we're just getting used to everything. For myself, I started working with my father when I was 17 years old at the liquor store, and I did it for more than half my life. I'm 36 now, and I also have an associate's degree in business, and I was a peace officer for the state of California, working as a correctional officer, and I'm still a licensed realtor in California.
That's great. Appreciate that. Thank you for being here. It's my understanding that both of you attended our restricted licensee gaming compliance seminar.
Yes, sir.
Yeah. And as you mentioned, you understand now how highly regulated the gaming industry is in Nevada, even just going down to the convenience store level. I assume the seminar impressed that upon both of you, correct?
Yes, sir.
Yeah, great. How's your business doing?
It's doing good. It's an old building, so when we first took over, everything started breaking apart, so we had to put in more into it than we were making, but slowly it's coming along.
Explain to me a little bit about how the slot machines were sold to you.
They were bought by the previous owner, and he put them into the contract when we bought the business.
During your conversations with our agents, did they explain to you that that's not the appropriate process from the seller side?
The only thing that I knew was that when we contacted the route operating company, he's the one that they purchased it from them, and they said that it was in the contract when we purchased the business and the land.
Right. And from a buyer standpoint, the burden wouldn't have been upon you because you didn't have the machines. But as a seller, there are certain requirements, federal requirements, state requirements that you have to go through in order to sell slot machines. Do you understand those processes now?
Yes, sir. I understand because once I talked to him and because he was supposed to file something saying that he made a sale of the business of the slot machines to us, but he didn't do that for some reason.
Understood. And now, if you get approved by the Gaming Commission this month, you will understand that as a licensee, that burden now becomes your responsibility if there's any sale or transfer of any gaming devices. And you're working with a slot route operator on a service agreement, correct?
Yes, sir.
And who is that?
It's can't think of the name top.
Was it Best Bet?
I gotta look up the email. I can't remember their name, but
that's okay.
They were his old company that was working with him, so we just took over the new contract with them.
Okay, so it's the same company. They know the devices.
Yes.
Do you know if those devices are in working order?
Yes, they're in working order.
Okay, yeah. And that's good that you got the same service contract company because they'll be able to determine that pretty easily, and they'll hopefully be able to explain to you. And I'm guessing that there'll be a condition upon this license that the enforcement agents of the Gaming Control Board have to come out before you turn these devices on, assuming if the commission approves your application later this month.
Yes, sir.
Okay, good. Dr. Watkins, did you have questions for the gentleman?
Good afternoon. Thank you for being here today. My questions, pretty much the chair asked and you answered. The only thing I would say is just to caution you to in the future, do your due diligence. And now you're a licensee, so the obligation is yours in this industry and in this context. But if, there may be other requirements if you decide to step foot into a new industry where, you as a buyer may need to do some due diligence to ensure that you're protected.
Yes.
Judge Assad, questions?
Thank you, Chairman Hendricks. Thanks for being here, gentlemen, by the way. The conditions, you've read those?
Yes, sir.
Any issues with the conditions?
No, sir.
Okay, great. And pretty straightforward application. Great job by Agent Martirosian. She did a very comprehensive analysis of this. And my concerns were addressed by the chairman's remarks regarding the machines, just so you know. If you do decide to sell, check with the tax and license people and let them know, and our agents and your lawyers, and you'll be able to do that transfer without any issues moving forward. So I'm more than happy to support your application.
Thanks, sir.
And is it my understanding that you filled out all this paperwork and handle this application yourselves?
Yes, sir.
Okay, good. That's no easy feat. So I commend you on that. And I would just tell you that if you do have questions, certainly seek out competent gaming and legal advice to be sure everything's done correct, as you understood from the restricted licensee compliance seminar. A highly regulated industry, lots of rules you got to follow. Otherwise, you'll be in front of us in a different situation, and none of us want that to happen. So we're here to support you, and hopefully it becomes a big success.
Thanks, sir.
Great. All right, then I would entertain a motion on restricted item number 3.
I move to recommend approval of restricted item number 3 as read into the record by Secretary Rupert pursuant to the following condition. Prior to the issuance of the state gaming license, the licensee shall enter into a service contract with a licensed slot route operator. The term of the contract shall be for at least a 1-year period of time. The surveillance system and/or mirrors must be inspected and are approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved. Upon licensure, Kismat Sharda, LLC, DBA, ARCO AMPM 42713, shall not expose slot machines for play prior to Enforcement Division approval of the slot machines.
And again, you understand those conditions. Okay, great. Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. The motion passes. Good luck to you, gentlemen. Please read in our next restricted item, Madam Secretary.
Restricted number 4 is the application of Zoni Brothers LLC doing business as Diamond Liquor and Market for a restricted gaming license, and the application of Zoni Gabriel for licensure as a member and manager as noted on the agenda.
Good afternoon. I have the pleasure of
Afternoon.
saying both good morning and good afternoon today. With me to my right is Zoni Jibrail. It's my pleasure to be here with him today. It's an exciting day. Mr. Jibrail has bought the liquor store about a year and 3 months ago and has been operating it for that whole time. They've been licensed, had no issues. He's a very hands-on owner. He works about 12 hours a day, at least on average. And he's here to tell you a little bit about himself and answer any questions.
Good morning. Please introduce yourself for the record and tell us a little bit about this location.
Good afternoon, everybody. My name is Zoni Jibrail. I own the store here in 3 months ago. I moved from San Diego at 2022 to Las Vegas. I used to drive semi. I used to own a company, Zoni Transportation Inc. Before that, I used to manage gas stations. I used to own a truck stop at Valmy, Nevada. Before that, I used to own also trucking company. Before that, I used to work at the gas station as a manager. I come to US at 2009. I'm originally from Iraq. I'm blessed to be here. There's a lot of opportunity to do good work, and I'm very hard work person.
Great. Pleasure to have you here. Your company's named Zoni Brothers. How many brothers do you have?
I have 4 brothers.
Okay, great. Are they here in the United States?
They are in San Diego, yes.
Okay, great. Do they have anything to do with Diamond Liquor and Market?
No.
No. You just name the company and honor your brothers.
Yes, because I love my brothers, you know.
Great.
Yeah.
And my understanding is this location could be zoned as a convenience store or a liquor store. Mr. Brown, can you explain why Mr. Zoni has chosen to have it as a liquor store?
It's basically the amount of liquor you have on stock. So it involves the percentages. He's elected to do it and have a smaller percentage be for, more convenience store items and a higher percentage for liquor.
And because of that, the zoning would affect the number of slot machines that could be at the location, correct?
Correct.
And this one we have at 4, is that correct?
Correct. He's aware and he's happy if he's granted the opportunity to have 4 and not seeking any more. Obviously, at this location, gaming really is ancillary. He's been open for over a year without gaming. He'd just like the extra opportunity.
Great. Business is going well?
Thanks God for everything. It's
Yeah.
good.
Good. You also attended our restricted licensee compliance seminar last month, is that correct?
Yes, sir.
Good. Glad you did that. Did you find it informative? Did you learn a lot about the gaming industry in Nevada?
Absolutely. We follow the law. Everything is
Good.
absolutely.
Yeah. And being a liquor store, you probably don't have much minor clientele already, right?
We don't. Yeah, we don't let nobody.
Are there?
All of them? They are adults. Most of the customers. Somebody walk in, we don't let them.
Can minors even come into the location?
They do, yes.
Yeah. Okay.
They are permitted if they're with a parent to come into the store.
Okay. Good. All right. So
They not with not the parents. We don't let them.
so then chances of them being around the devices is
Yes.
very minimal.
Absolutely.
Good. Wonderful. All right. Dr. Watkins, questions?
Good afternoon, Mr. Jibrail. Thank you for being here today. You have a very positive demeanor, a positive and very grateful demeanor. So I trust you will take this opportunity and flourish. I'm happy to support your applications.
Thank you very much.
Judge Assad, questions?
Thank you, Chairman Hendricks. No questions, just some comments in general. Agent Lombardo did a very good job of preparing us for this. So everything is in the application that I needed to go over. The chairman expressed some concerns that I had as well. So all those questions have been satisfied. You have plenty of work experience. I'm sure you'll do very, very well. You're okay with the condition? You've gone over that with him, right, Mr. Brown?
Yes.
Okay, great. And so you were about 28 years old or so when you left Iraq?
I was 22 years old.
23.
22, the time we left Iraq, we went to Turkey.
Okay.
From Turkey, the UN, we applied for all the paperwork because we can't stay in Iraq. It was too dangerous for us.
This during the Gulf War?
I'll say again, I'm sorry.
Gulf War? Did you get out before, during the Gulf War?
So 2003, we are there. At 2008, we can't live anymore there because we can't no more because of the races. I'm Christian from Iraq.
Yeah, Chaldean.
They tried to kidnap us a few times.
Yeah.
Over there is different.
Right.
So we have family, a lot of family in Michigan, a lot of family in California. So we did all paperwork, and UN helped us a lot. And in 10 months, we are in San Diego.
There's a large Chaldean community in San Diego.
Yes, I'm Chaldean, yes.
Nice, good. Well, thank God you're here.
Thank you.
All right.
Appreciate it.
I'm happy to support your application.
Thank you very much.
And Mr. Brown, please say hello to your wife. We miss seeing her around, so.
Will do. And I would also like to thank Agent Lombardo. Like you said, he did an excellent job working with us, and we really appreciate all of his help.
Great. Thank you for that. I would entertain a motion then on this restricted item.
I move to recommend approval of restricted item number 4, is this?
4.
As read into the record by Secretary Rupert. Does this item have conditions?
I think it does, yeah.
This one, okay. Sorry, my paperwork is everywhere. I need to organize it a bit more. Okay. Pursuant to the following condition, the surveillance system and/or mirror must be inspected and are approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Good luck to you. Thank you. Thank you. Please read in restricted number 5, Madam Secretary.
Restricted number 5 is the application of United Coin Machine Company doing business as Century Gaming Technologies doing business at Las Vegas Eagle for a restricted gaming.
Good afternoon. How are you?
Good afternoon, Chair Hendrick, Member Assad, Member Watkins, and Madam Secretary. For the record, my name is Debbie Cornine. I am the Director of Compliance for Century Gaming. The application before you, as read into the record by Madam Secretary, is that of Century Gaming Technologies doing business at the Las Vegas Eagle. With your approval, I would like to highlight a few items regarding this application. I think will shed a little bit of light. This is an interesting location. It's been around for quite some time. It is located on 3430 East Tropicana Avenue in a general commercial shopping center. It's a large shopping center and has numerous different retail outlets within it. The Las Vegas Eagle occupies suites 46, 47, and 48 within that center. This location is considered a county grandfathered location, and it ceased operations on May 25th, 2023. And as such, they need to reopen the location by November 25th, 2024 in order to maintain that grandfather. This location is not a location that is unfamiliar to Century. Century actually contracted with the previous operator in July of 2000 and continued to operate as the SRO in that location for numerous years. Matter of fact, up until they ceased operation in May of 2023 when as a result of the passing of the owner of that location. After her passing, the family did not wish to continue and proceed with licensing and or operating location. They ended up selling the property to LV Eagle Management LLC. Century has since contracted with that LLC as and they wish for us to go forward as the licensee for the gaming operation. It's my understanding that the applications that are currently pending with the county should receive full approvals, hopefully by the end of October, but at least by the expiration date for the grandfather in November. If all that happens, Century anticipates going in there as soon as all approvals are received and operate 15 gaming devices that will be embedded in the bar. And they need to be embedded in the bar as part of the county requirement. So they cannot have machines on the floor or anything of that nature. I think there was a little bit of confusion on that throughout the application process, but they must be embedded in the bar. Another item I would like to bring up is the fact that within this shopping center, there is a church. It's a very small church, but it happens to be very close to the bar. There's also two other bars within that shopping center. There's one standalone, as I believe it's the Founders Club, but then there's also Blue Dogs, which is just very, very close right down. So there's two other taverns in the same area. But with regard to the church, there's an agreement with the landlord of the center and the tenant that there's a patio area outside of the that is outside of the Las Vegas Eagle. It's a small patio area, about 16 by 18 feet, and it cannot be accessed from the outside. It can only be accessed from within Las Vegas Eagle. The request was that that patio area remained free of any noise, any commotion during the hours that this church has services. I believe they hold services Sunday morning, Wednesday, and Friday. Las Vegas Eagle is completely understanding of the necessity to respect and abide by the conditions as set forth in the addendum to the lease agreement. Other than that, I'm here to answer any questions you might have.
Thank you, Ms. Cornine. Appreciate your explanation and some of the background. You mentioned one church. Our notes, I thought, said there was two churches in this shopping center.
There is, but it doesn't. That is not the one that seems to be, any issue with as far as the noise or anything that would be intrusive. It was the church on the other side that seemed, because that church, I believe, the one that's closer is in Suite 50, which puts it fairly close. And we were, not requested to, do anything with regard to the other church. It seems to be a much smaller operation.
Got it, understood. And as you know, our regulations always require us to delve into the facts and scenarios around any potential licensee that's within a certain amount of distance between a religious establishment or a school. And so your company has contacted both of these religious organizations?
Actually, the operator has been in touch. Yeah, the operator, yes.
And the one they worked out, as you mentioned for the record, that there will be certain times they don't use the patio area.
Correct. Right now, I did have a lengthy conversation with the operator, and he said that right now they don't even have any intention of using that patio area at this point in time. And certainly not within the hours of any religious meetings or anything taking place within the area.
And you stated also for the record that your company has been involved with this location for a couple of decades, right? It's been open longer than that. So this isn't any question about a gaming encroaching upon a church or a school. They've coexisted for many, many years.
Yes. Well, and they've been there. They were there prior.
Yes. Exactly. Well, that's good for me to know for the purposes of the record and the fact that they are in communication. Doesn't sound like we've received any objections from either of the religious establishments regarding there being gaming at this location. They obviously would have known that for many, many years. So this isn't a new scenario for them. They would have had ample opportunity over the last 20 plus years if they had any concerns. So again, I'm glad to see that they're working out the patio area if in case it was used. That's really a zoning issue more than for us.
Correct.
Our question is, can there be gaming at this location? I've seen no objections, so I'm personally comfortable. We also had in our records that I believe this has been around since 1987. I believe you mentioned 2000 that Century took over?
2000 is what my understanding is. Of course, I wasn't there at that point in time, but I was told they took over in 2000.
So then for the record, even prior to that, Las Vegas Eagle has been there for many years.
Many years,
so
yes.
I don't think it's a question again of somebody being surprised that gaming would have been at this location.
Right.
And as you mentioned, there's other taverns also.
And my understanding is other taverns have been around for a very long time as well.
Okay, great. Yeah, I kind of know that area. Didn't grow up right in that area, but grew up in East Las Vegas. So know that that establishment has been there, Las Vegas Eagle, for many, many years, and may pre-existed the churches in that shopping center would be my guess.
That's my understanding.
Okay, great. Then I'm satisfied for the purposes of our regulations and the distance requirements, and there being no objections from those church establishments. I'm personally comfortable with this. Dr. Watkins, questions or comments?
Good afternoon.
Good afternoon.
Thank you for being here. I'm satisfied with the conversation that you and the chair have had on the record. It seems to me that you've demonstrated your burden to prove that this location is suitable for gaming, and I'm happy to move forward with the application.
Judge Assad?
Thank you, Chairman Hendricks. Nice to see you again, Ms. Carnine. I don't have any questions. I'm happy to support this application.
All right, then I would entertain a motion on restricted item number 5.
I move to recommend approval of restricted item number 5 as read into the record by Secretary Rupert.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, the motion passes.
Thank you very much. I want to also give thanks to the agent, as always, as with all the agents. We work very well together, and it's never, I've never been disappointed by their professionalism and how they always timely respond to everything that any questions I might have, and I truly do appreciate all their efforts.
Great. Thank you for putting that on the record. Madam Secretary, does that complete our restricted items?
It does.
All right, then what is our next item on our agenda?
You have one request for final approval of a new game. That item is Double Down Madness, submitted by Light and Wonder.
All right. Good afternoon.
Good afternoon, Mr. Chairman, Dr. Watkins, Judge Assad, and Madam Secretary. I just want to say thank you very much for this opportunity. A little bit about my background, just for the record. My name is Matt Booth. I'm originally from Iowa. I started my career in gaming when I was attending college. I was going to school for law enforcement, and I had the opportunity to be a table games dealer on the weekends. During that time, I was kind of fell in love with that career path and was given the opportunity to move to Las Vegas. And with that being said, I was very fortunate with some of the doors that have opened up. And I started my career at a few of the like New York was one of the places I started at. Fortunate to move to Bellagio. And then during 2020, we were all let go for the obvious reasons, and I moved back to Iowa. Then during that time, I did get a call for Resorts World to go and open that up, and I was fortunate enough to be able to start full-time as a table game supervisor, and was very excited for that opportunity. So I moved back to Las Vegas. During that time at Resorts World, I worked for about a year and a half, 2 years there. And then I got presented the opportunity to work with Light and Wonder. And I was brought on as a table games product manager. And I'm currently about 2.5, 3 years with the company. And during that time frame, I was very fortunate to be able to create a new game called Double Down Madness. And so today I'm here to request for the final approval. And I believe that there were a few questions, and I'm more than happy to help answer those questions.
Thank you. Pleasure having you here today. What's your current title at Light and Wonder?
Yes, I'm an associate table games product manager.
Okay, great. And how long did you say you've been there?
Around 2.5, 3 years.
Okay, great. Tell us a little bit about the game.
Yes, so the game is a blackjack variant. It is based on the player receiving one card, and during the round they have the opportunity to hit and double down as many times as they choose to. With that being said, it allows the player to have more control on every action that they have with their card that they receive. And then what they have in place is a push 22 element. And that is based on the dealer receiving a total in their hand. If it's 22, all base bets result in a push, and there is a side wager that players can place, and depending on which pay table is being used, they will receive that payout.
And what made you come up with this game?
Great question. I think just with being in the time of being a table games, seeing multiple, examples, hearing what customers and what the market was wanting, I just kind of put all of those elements together and sat down and really, really thought it all through. And so far, we did do a field trial with New York, and so far across the board, we have received positive feedback. And with table games, there hasn't been really much excitement. And so far, what we're seeing is that this is being more excitement, bringing back to table games.
So expound on that a little bit. How was the experience by both the players and the dealers? Tell us a little bit about the interaction.
Yes, great question. So what we were seeing just with the little bit of time frame that we had with our field trial is that the players were engaging with teaching other players how to play the game. The dealers were able to catch on to the procedures that I created because of being a dealer, table games dealer, that I knew what dealers knew, that they were able to pick it all up within a few hands. And just with the way of betting, the structure of being able to hit, double down, the players started showing more excitement. They were more engaged with gameplay.
And did you get the opportunity to go watch your game be played by patrons?
Yes, sir.
Yeah, and how was that to see your invention be actually played on the casino floor?
I honestly, it was, it's very interesting. I honestly, because the way that this all started was, I don't want to go way too deep into the weeds on this, but when I was developing this table game, I was thinking about it before I went to sleep, and I woke up with procedures in one of my dreams I had, and I literally woke up and started dealing it out, and just that little element right there was enough to start this whole process. And to see dealers dealing the procedures that I created, and to see players interact and engage in this is one of the most craziest feelings I've ever had. This is probably the hardest thing I've ever done in my life, and to see it come in fruition like this has been incredible.
That's great. That must have been a wonderful experience, and like you said, a lot of different emotions. So
yes, sir.
Glad you could recount the story for us. For the purposes of the record, as you know, having worked with our agents, we have a very detailed file, and has lots of information in there, including description of the rules, written documentation regarding any copyrights, patents, trademarks, a proposed schedule of payouts, the fact that you had a statistical evaluation that had to be done by an independent testing lab, the results of the independent testing lab, and the certification process. For the purpose of the record, that is all in our investigative materials as required by Nevada Gaming Commission Regulation 14. And as you also noted, there was a field trial that you got to witness personally, so appreciate you putting that on the record. Dr. Watkins, did you have any questions?
Good afternoon, and thank you for being here with us today. I'm very glad to hear that the experience was so rewarding for you. That was one of my questions, and one of my questions was this a difficult process? And you said it was one of the hardest things you've ever done in your life. My next question is, what would you recommend to, or what advice would you give to someone who wants to develop their own new game? What business relationships, what kind of capital, what length of time, what kind of knowledge did you need to develop this process?
Yeah, it's a very great question. Thank you. The first thing I would say is you want to make sure that the dealer understands the game and that they're comfortable with dealing it, because at the end of the day, they are the sales reps for the game. If a dealer doesn't like dealing it, they're not going to enjoy dealing it to other players. The second element is can players understand it within 30 seconds to a minute? And then the third piece is that can you place the element of the house advantage at a very fair rate, where that way it is still favorable to the casino as well as it's not taking a lot from the player, so that the RTP is still very favorable.
Mm-hmm. What kind of investments did you have to make to develop this game?
A lot of time.
Yeah.
Yep. And I'm very fortunate with my company Light and Wonder for taking a gamble, no pun intended, on this, because they helped do a lot of the backing on this.
Mm-hmm. All right. Well, thank you. Appreciate you being here today.
Yep.
Judge Assad?
Yes, thank you, Chairman Hendricks. Thanks for being here. It's a very interesting concept you have. Do you know what the hold percentage was after the trial?
The overall hold, yes, it's between, so since it was only 45 days, a lot of that fluctuates, but I would say it's between 25 to 30% hold.
Say again?
I think it was between 25 to 30%.
25 to 30.
Yeah.
And normal, regular blackjack would be about what? 15
to 20-ish. So, all that always fluctuates with the
Depending
drop
on the
in.
count,
Yeah. Table games is, very interesting because it's never consistent.
Skill and expertise of the player.
Mm-hmm.
So the players get dealt one card face up, right, to start?
Correct.
And the dealer gets face up and underneath card?
That's correct.
And
so
then,
the dealer starts with 2 cards. Each player starts with 1 face-up card.
And then after the first card is dealt to the players, they can either double down?
Correct.
Or any other options? Or just double down till they get the second card, that's it?
Mm-hmm. Yep. So the players, they get the option they could take a hit, they can double down, or they could stay if they choose to, but with 1 card, it's
you're not
players
gonna stay
aren't
on
going
one
to.
card.
Well, I shouldn't say they aren't going to, but they're more likely to take at least a hit.
Of course. And then the side wager is only if the dealer has a 22?
That's correct.
What are the odds on that?
The odds so the hit frequency on that is about 7% based on 100 hands. And the odds.
What did the player get? Is it even money?
Depending. So we do have 3 different pay tables. The one that we are currently using during field trial, it was 11 to 1.
Okay. And then the hand continues, the player gets a second card, and then again, they can either double down, split, or do whatever they want, pretty much, right?
So yeah, with this variant, the player, they do not have the option to split or surrender. They can redouble. So just to make it easy, if a player has a $5 wager and they choose to double on their first card, they have a total of 10. Now they like their second card, they can choose to redouble and they can match up to the amount that's already in play. Okay. So during the round, the player can hit and double down as many times as they choose to during that round until they choose to stay or they end up breaking out of their hand.
And is if the player gets a blackjack, is it 6-5 or 3-2 odds?
With this variant that we did, we have two payouts now. So we have suited blackjack that pays 2-1, and we have 3-2 for unsuited blackjacks.
Very good. Okay, great. Thanks. I
Yes,
have no
sir.
further questions. Thank you.
And then the last thing, for purposes of the record, it's incumbent upon the board to be sure that any new game complies with Nevada's public policy as defined in Nevada Rise statutes and NGC Regulation 14.250. And based on everything we have in our files today, I feel very comfortable that providing any new game is always important. Providing games that customers like and is good for the industry, I think that's perfectly fitting with Nevada's public policy. So I'll state that for the record, that it is very consistent, and always appreciate new games being brought to increase the economic value of our industry, to help our state, its taxpayers, and everybody involved. So thank you for that. Anything else from board members?
Not by me.
Anything else you'd like to add?
Yes, just for the record, I do want to make note that I do want to thank my team, my marketing team, and everybody else who helped support this, because this was about a 2-year process in the making. So
great, thank you for that. I would entertain a motion then on this item if a member would like to make it.
I move to recommend approval of this new game to be adopted by the commission.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, the motion passes. Thank you. Good luck to you.
thank you, everyone.
Madam Secretary, what is our next item?
You have one casino player dispute appeal. That item is Oscar Salazar versus Bellagio Vet MGM LLC, case number 23LV01049. The hearing examiner recommends the agent's decision denying payment to the respondent be affirmed.
Thank you, Madam Secretary. I have reviewed the recommendation of the hearing examiner as well as all the exhibits included with our file. I did not have any questions or comments regarding the file or the recommendation. I want to confirm for the record that my fellow board members also reviewed the hearing examiner's recommendation, reviewed all the exhibits, and don't have any questions or need to provide any discussion regarding the recommendation. Dr. Watkins?
Yes, I've had an opportunity to review the same, Chair, and I do not have any questions or points for discussion.
Judge Assad?
Yes, thank you, Chairman Hendrick. So I've also reviewed everything, and it's pretty clear cut. The rules stated that overtime is not included in the original bet, so I support the hearing officer's decision as well.
Thank you both, and I would just also say for the record that I think it's incumbent upon all of our licensees to be sure that their house rules are as clear as possible, and to be sure that patrons have the opportunity in any instance to have the opportunity to read those rules. And I know that most licensees take that very seriously, and I think the record here also shows that that was an opportunity for the patron to have reviewed the house rules before placing a bet. If there's no further discussion, I would entertain a motion to accept the recommendation of the hearing examiner.
I move to approve the hearing examiner's recommendation that the agent's decision to deny payment be affirmed.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. That motion passes. What is our next item, Madam Secretary?
You have one regulation agenda item regarding proposed amendments to Nevada Gaming Commission Regulation 8.130 as noted on the agenda.
Good afternoon, Senior Deputy McKellar.
Good afternoon, Chair Hendrick, Member Watkins, Member Assad, Madam Secretary. For the record, I am John McKellar with the Attorney General's Office. Before you today for your consideration and possible recommendation to the Commission are very straightforward proposed changes to Regulation 8.130. The draft before you is dated September 6th, 2024. The purpose of the draft before you today is to exempt from reporting all transactions which were previously reviewed by the board as part of an investigation. Currently, just loans and other financing activities previously reviewed by the board are exempt. The proposed change would make all previously reviewed transactions exempt from further reporting. The specific request for this change was for leases that were previously reviewed. The reason for the proposed change is that these transactions do not raise any regulatory concerns for the board, as they have previously been reviewed. I'm happy to answer any questions you may have, and I would also note for the record that Chief Chan Lang-Savath with Tax and License is here as well. Thank you.
Thank you, Mr. McCullough. Madam Secretary, did we receive any public comments regarding these proposed regulatory changes?
We did not.
All right, thank you. And so you've explained to us the legal reasons for this. Is there a layman's term that you can explain to us why the commission needs to revise Regulation 8?
In simple terms, the board has already looked at it. This would just require the board to look at it again if the reporting requirements were implicated in 8.130.
So again, what we've been trying to do for the past year and a half or two is streamline the industry requirements, streamline the Game Control Board's business, and this sounds just like it's redundant. Is that correct?
I think that's a fair assessment, Chair.
Great. Chief Lang-Savath, is there anything you'd like to come forward and tell us about this proposed revision to Regulation 8?
Chief Lang-Savath for the record. No, I just wanted to back that up by saying that this was an issue that came up recently with the industry, and they didn't ask for it to be changed, but it's one of those things where, like you mentioned, Chair, we tried to streamline things as best as possible, and so I just took it upon myself and for the division to just go ahead and get rid of it because we all kind of agree with it anyway, but just to clarify within the regulation.
I appreciate that and commend you and everybody in Tax and License for that philosophy. The idea if it's redundant or excessive for no reason on the industry or upon the Gaming Control Board to do something that just isn't necessary in order to collect the right amount of tax and to be sure that the game is fair and to be sure that we're doing everything we have to do as a good regulatory agency. If we're doing something twice when we can do it once, good for you. So thank you for bringing this to us.
Right, and if anything changes, for the lease, of course, they would have to resubmit at that time because then we would have to take a look at it. Material changes anyways.
Good. Thank you for noting that for the record. Dr. Watkins, did you have questions?
I don't have any questions. Just wanted to say thank you for being here, Chief Lang-Savath, and thank you to Mr. McCullough for providing us with a presentation, and to you both for your initiative in drafting. I support this change. I think it helps to eliminate unnecessary requirements, and thank you to you two for bringing it to us here today. That's all I have, Chair.
Judge Assad, questions, comments?
Yes, thank you, Chairman. No questions. Just like to thank you both for all the work you've put into this.
Mr. McCullough, anything else you'd like to add?
Just as part of the motion, you might want to recommend an effective date upon adoption. Savath has another desire.
Chief, does that make sense to make this effective upon adoption by the commission?
Makes perfect sense.
Okay, thank you. Then I would entertain a motion on our proposed Regulation 8 revision.
Might I ask you, Chair, what draft date do you have?
I am looking at draft date September 6, 2024.
Okay. I hereby move that the board recommend for consideration and adoption by the Nevada Gaming Commission the proposed amendments to NGC Regulation 8.130 as presented in the draft dated September 6, 2024.
Effective upon adoption by the commission.
Sorry about that. Effective upon adoption.
Great. Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes. Thank you, gentlemen.
Thank you.
All right, Madam Secretary, what's next on our agenda?
We are at our final public comments.
Public comment. All right, please go ahead with that.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters. As stated at the time of the public comment section at the beginning of the meeting, anyone wishing to address the board may do so at this time. Comments by each person are limited to 3 minutes as a reasonable time, place, and manner restriction. If board members ask questions of the speaker, the time needed to address those questions will not count against the speaker's 3-minute time period. If speakers have any handouts or written copies of verbal comments to provide for the record, please hand them to the enforcement agent in the room.
Thank you, Madam Secretary. And I should, for the record, I know we voted already on the proposed Regulation 8 revision, but I did not ask if there was any public comment. I didn't see anyone in Carson City at all. I see some empty chairs, and I didn't see anyone here in Las Vegas jumping up and down, demanding to be heard. So for the record, though, let me be clear. If anybody wants to speak on the proposed Regulation 8 revision, we can do that now. All right, seeing none, then we will stay in public comment that Madam Secretary has read in. As stated previously, pursuant to Nevada State Open Meeting Law, matters brought to the board's attention cannot be acted upon. But of course, we want to hear from anyone in your comments as well as comments from my fellow board members. Is there anyone in Carson City wishing to make public comment this afternoon? Seeing no mad dash to the podium, let's go here to Las Vegas. Anyone in Las Vegas wishing to make public comment? Still nobody running to the front? All right, then we will go ahead and close our public comment section. And with that, Madam Secretary, I believe that concludes our Game Control Board meeting for the month of October 2024. Thank you all for attending in person and virtually with us today. We are adjourned. Nailed it.